Honorable Judge J. Cedric Simpson to die.
May be seated. Ms. Lundy.
Good morning, Your Honor.
Long no see.
I know it. Your Honor, Ashley Lundy for the people. At this time, the people would waive any conflict in this honorable court in the office of public defender. The people do not believe that any conflict exists. Make the avoidance of all doubt.
Thank you. Let it be Miss Payne. Mr.
It could be Miss Payne.
No, go ahead.
Thank you, Your Honor. But I'll mess up the word. Public defender Natalie Pate of the Public Defender's Office, Your Honor. Likewise, Your Honor, our office does not believe a conflict exists between this honorable court and our office, but if one were to arise, we would wherefore waive such a conflict.
All right, thank you. And Ms. Parody, there was no disrespect in that. All right. The court, for its part, does not believe that there's a conflict either in Michigan court rules or the cases decided they are under, to the extent conflict does exist, given the waivers, the court will consent to hear the matters. Court does call the case of the People versus Diane Mohammed.
Good morning, Your Honor. Christina Barrett-Darren requesting permission to practice pursuant to Michigan Court Rule 8.120 under the supervision of Assistant Prosecuting Attorney Ashley.
It's good that you've taken the first seat. Permission to practice is granted.
Thank you, Your Honor. Christina Barrett-Darren for the people.
Assistant Public Defender Natalie Pate with and on behalf of Mr. Mohammed Diane. Please state your name for the record, sir.
Mohammed, pronounced John, spelled D-I-A-N-E, Diane.
They have it backwards in here, but anyway, all right.
Thank you, Your Honor. So it appears that last time when I requested an adjournment of this length, I was a little too optimistic in how quick I may be approved for a visit by MDOC. I did get notified, it was about a week and a half ago, that I had to supplement my online application with some stuff through the mail. That being said, I did submit my paper application through the USPS. I have not heard back yet whether or not I have officially been approved. My client is located in a facility very up north, but I am optimistic that within a few weeks, hopefully I would be approved and be able to get that video visit scheduled. Progress has been made, but we are still on that journey. So I would be asking for an adjournment. Frankly, it might be a while, maybe a month out.
That's what I was thinking. So today's the 18th, right?
Yes.
I was gonna say, I have court coming up in a different county too, so if I would be included in this scheduling, it'd be good for us.
I'm sorry?
I have court coming up in a different county, so if you let me know what date y'all gonna pick it, help me out, so, cause I have a court date coming up in a different county. I don't want it to interfere with.
Do you know when that is?
I think it's, give me 1 second. You know when my next court date is? I think it's July 15th or, you know when my next court date is for Jackson? You know when my next court date is for Jackson?
It's on the calendar.
All right. John, if you give me 1 second, you guys tell me right now, you're looking at the calendar.
Mr. Diane, you think it's sometime in July?
Yeah, I think it's July 15th, if I'm not mistaken.
All right. Well, rather than give you, my next court date would be July 16th, but that may be a bit early given what they're trying to do here. So let me just adjourn this to August 6th.
Since I'm gonna be going on a writ over there, that's why I was saying I'm not gonna be in MDLC, I'm gonna be going out there to Jackson.
Oh.
When is that supposed to happen?
That's what I'm saying. Is it July 15th? Is it July 15th?
Okay. All right, Mr. Diane.
What's that?
Did you look at that calendar for me?
I haven't got a chance yet.
All right. Yeah, I'm not, I think it's July 15th. I haven't got the paper yet though, but they haven't sent me the paper. But I know it's like July 15th or something.
All right, let me do this. I'm gonna keep the date of August 6th. If they move you, we'll get notification in time to do a writ if necessary. Okay?
Okay. All right.
All right. Thank you, sir. Bond will continue.
And thank you, sir. Thank you, Your Honor.
Thank you, Your Honor.
Court does call the case of the People versus Gabriel Boyd.
Christina Barrett-Darren for the people.
Good morning, Judge Aida Spahich on behalf of Ms. Gabriel Boyd. Judge, hello, all the way from Bosnia.
Oh,
It's nice to be able to work, be in another country, Judge. Thank you
Yes.
for letting me allow me to appear via Zoom. I don't see my client on.
and they are not in the courtroom.
There, okay, let me just double check with my client because I spoke to her yesterday. Can we pass this matter, Judge, for about a couple minutes?
Okay,
Thank you, Judge. I appreciate it.
not a problem. It's
Thanks.
hoping to issue an overseas bench warrant. Court does call the case of the people versus Michael Klustra.
Ashley Lonnie for the people.
Good morning, Your Honor. Uwe Daus on behalf of Mr. Klustra, also joining us by Zoom. Thank you for the remote attendance. Mike, please unmute and identify yourself.
Michael Klustra?
Here, the people are going to be filing a nollie in the interest of justice.
You're going to be filing a nollie on it?
Yes, Your Honor.
All right. Any objection to that, Mr. Duff?
No, we don't. We spoke with Ms. Landy,
All right.
and it's much appreciated.
This case is dismissed.
Thank you, Your Honor.
All right. Thank you.
Thank you.
Today is 6/18. Court does call the case of the people versus Damian Poupet.
Ashley Lonnie for the people.
I'm here, Your Honor. My attorney is supposed to be on here too, but can't seem to find him.
Your Honor. But he is not right now.
My staff is indicating he was in Zoom, but he's now not. So let me pass it and see if he reappears. Okay?
Okay.
Thank you, sir. Court does call the case people versus William Parker.
Ashley Lonnie for the people.
Good morning, sir. Tom Pietrowski on behalf of William Parker, who's in court today, standing to my right. If you would identify yourself, please, sir. Yeah, my name is William Parker.
Thank you. And good morning, Mr.
Good
Petros.
morning, sir.
All right, what are we doing?
I've had a chance to talk with Ms. Landy regarding a potential resolution of this. We're going to look into sobriety court. We're going to ask the court for some additional time to take care of the necessary.
I'll adjourn the matter then to July 16th, 2025, 9 a.m. I'll mark the file that you're looking at sobriety court.
Thank you,
Thank you,
sir.
Your Honor.
Thank you, Your Honor.
All right, thank you. Court does call the case of the people versus William Depkowski.
Christina Berger for the people.
What is this set for?
This is an arraignment and pretrial, Your Honor. Mr. Tefelsky is physically here.
Depkowski?
Yes,
Where is he?
not in court. But he has been here.
You know what, Ann? You're gonna make this day longer for me, aren't you? Can you,
I can do it, Your Honor. It's okay.
Good morning, Your Honor.
good morning.
Paul Tefelsky, P52844 on behalf of Mr. Dapkowski.
Okay. And I don't have an appearance, counsel, for whatever.
Oh, you don't? I'll make sure I file one with the clerk. It should have been filed
Very
a
good.
couple weeks ago.
I just don't have it. All right.
Okay.
Okay, as to the arraignment in this case,
Judge, I'll waive the formal reading. My client stands mute.
defendant having waived formal reading, standing mute, court will enter a not guilty plea.
Judge, I understand that the prosecutor is requesting a tether. My client is not opposed to proving his sobriety and taking and testing. However, we would ask the court to consider an alternative to the tether because he is a mechanic and he works with a lot of chemicals. And he was just explaining to me how the other day he was removing a gas tank from a vehicle and about 1.5 gallons of gas spilled on him. And I have had experience with clients before where if they get alcohol-based products on their bodies and on their clothing, it can cause false positives. And I don't want to have that happen with him. So I would ask the court to consider.
Well, but it's only going to look like a drinking event if he drank the gas.
Well, I think even
When they run it through the bottles, it's not going to look like a drinking event. I mean, I'll take that into consideration, Councilman.
That's fine, Your Honor. I've had clients before that worked in paint booths, and the manufacturer recommended against it in those instances. But that's our only concern, Judge. It's not proving his sobriety. So we would either ask for a sober link or a random ETG testing. And
all right, you want the pretrial adjourned?
We'd ask for the pretrial to be adjourned, Your Honor. We're going to have him screened for sobriety court, see if he's a good candidate for that.
I'll adjourn the pretrial to July 16th, was it?
We have the second.
We also have a second. Well, if he's going to get screened, he's in Saline, so actually he might qualify for ours. So let's do July 2nd, 2025.
Judge, I'm going to be out of town that day.
July 16th.
Thanks.
2025, 9 a.m. As to bond in this case, Ledge BAC.
0.13, Your Honor.
Your Honor, if I may, it was 0.137 and 0.134.
Accident.
Your Honor, no accident. He was pulled over for speeding 30 miles per hour over the limit.
All right.
He does have a prior OWI from 2022.
He has a prior.
Yes, Your Honor. For those reasons, that's why we were asking for the scram.
Anything else you want to say before I step out?
No, Your Honor.
All right. Bond will be set in the amount of $15,000 personal recognizance bond. I'll order standard conditions, including no assaultive behavior or possession of any weapons. You understand that, sir?
Yes.
There should be no possession or consumption of any alcohol, recreational marijuana, or any illegal drugs. I am given the prior in this case, and we'll monitor it, and I'll hear argument if there is a problem. But I am going to order the defendant be placed on a scram tether. And you'll need to report to community corrections within 24 hours. So it might be best just to do it before you leave this facility because they're right over there.
Okay, thank you.
Okay.
Thank you, Judge.
They are.
Yes.
Court does call the case of the people versus Jason Brooks.
Christina Berger. Good morning, Assistant Public Defender Lauren Penny on behalf of Mr. Brooks.
Mr. Brooks, can you state your name, please?
Jason Brooks.
Thank you.
Your Honor, I am requesting an adjournment. I did not have a chance to speak with Mr. Brooks prior to today's hearing. I would ask that he return my calls, please.
All right, sir, you need to keep in contact with your attorney. You hear me?
Yes.
I'll adjourn this to July 2nd, 2025, 9 a.m. Thank you. Court does recall the case of the people versus Damian Coupet.
Ashley Lonnie for the people.
Morning, Your Honor. May it please the court, Ezra Goldman. I'm asking Mr. Pupett. I'm sorry if I missed it previously, Your Honor. I was in another court.
Okay. So you'd rather appear in another court than mine? No, never mind. Don't answer
No,
that.
well, okay.
All right. Is this an arraignment?
Yes, it is, Your Honor.
All right, this is an arraignment on an OWI. High BAC.
Waive reading, stand mute, please, Your Honor.
All right, defendant having waived formal reading, standing mute, court will enter not guilty plea. You wish an adjourned pretrial date, sir?
I do not have discovery yet, Your Honor.
All right. I'll adjourn the matter to July 2nd,
Your Honor, I have to
2025.
be in, I'm sorry, Your Honor, I have to be in the district court in Taylor that morning. And while I would rather be in Ann Arbor, but
Yeah, okay, all right, yeah. July 16th, will that work for you, sir?
Yes, it will, Your Honor.
All right, July 16th, 2025, 9 a.m. As to bond in this case.
Your Honor, the people are requesting a scram tether. The alleged BAC in this event is a 0.192 blood alcohol content. The defendant has a prior OWI that was reduced to a reckless in 2020 and a conviction for OWI in 2024.
So we are concerned in this case that the blood alcohol content and the recent prior, there was no crash.
Sir, anything you want to say regarding bond?
I can't dispute those priors. I don't have the discovery to know if the blood alcohol was correct, but I have no reason to think that it isn't. So,
all right.
I will tell the court that Mr. Pupette is not driving, and he
Okay.
lives down. So his work is remote. So that's something.
All right. I will set the defendant's bond in an amount of $20,000 personal recognizance bond. I'll order standard conditions, including no assaultive behavior or possession of any weapons or ammunition. I'll indicate you are not possess any alcohol, recreational marijuana, or any illegal drugs. I will at this time order that the defendant, given the what may be 2 priors, but at least 1 prior and the high BAC, that the defendant is placed on a scram tether. All right. You need to report to community corrections within the next 24 hours, sir. Okay. All right.
Your Honor, I'm attempting to get into the Zoom call to give defense counsel where he needs to send his appearance for discovery. It's just taking me a moment. So if he could hold the line for a second, I'll have that to him momentarily.
I will be happy to stand by. Thank you.
All right. Thank you. Court does call the case People versus Andre Smith.
Ready, Your Honor.
Judge Maloney for the people.
And Your Honor, Joe Simon, on behalf of Mr. Smith. Mr. Smith, when you get up here, state your name, please.
Andre Smith.
Thank you.
Your Honor, I believe, well, sorry, we're here for arraignment as well. Waive formal reading of the complaint, stand mute.
Defendant have a waive formal reading, standing mute. Court will enter not guilty plea.
We're going to be making a travel request in a little while, but we've reached a resolution on the with respect to the pretrial.
That's correct, Your Honor. The defendant is going to be pleading guilty as charged with the prosecutor's deferred sentence.
Your Honor, that's accurate. Mr. Smith and I reviewed his advice of rights form today. He signed it. It should be before you, and he's ready to enter his plea. Just have a half a step forward, Andre.
May I have him sworn?
Raise your right hand. Do you solemnly swear and affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth shall be God?
I do.
State your name.
Andre Smith.
All right. So he's pleading guilty as charged with the prosecution.
Yes, sir.
All right. Sir, it is this court's understanding that you are going to be pleading guilty to the charge of retail fraud in the 2nd degree. That is a misdemeanor punishable by up to 1 year incarceration, $2,000 fine plus court costs. The fine could be increased at 3 times the value of the property taken. If that's greater than $2,000, that would become the maximum fine. You understand that, sir?
Yes, Your Honor.
All right. Understanding all of that, you still wish to plead guilty?
Yes, Your Honor.
And to that charge, how do you plead?
Guilty.
Now, you understand that by pleading guilty, you will not have a trial of any kind.
Yes, Your Honor.
All right. You signed an advice of rights form, is that correct?
Yes, Your Honor.
Any questions regarding any of those rights?
I know, Your Honor.
Please look at paragraph 5 of that form. You'll see a copy of your rights, which are part of a trial. You understand that by pleading guilty, you'll be giving up those rights as well as all the rights under the form.
Yes, Your Honor.
You understand you're giving up your right to appeal of right?
Yes, Your Honor.
All right. Are you on probation or parole?
No.
Has anybody promised you anything other than what's been stated here today on the record to get you to plead?
No, Your Honor.
Anybody threaten you or coerce you?
No, Your Honor.
You're doing this voluntarily?
Yes, Your Honor.
And of your own free will?
Yes.
And also because you believe that you are indeed guilty of this offense?
Yes, Your Honor.
I would also indicate to you that if I do accept your plea, between the time of this acceptance of the plea and time of sentencing, that if you commit any type of misconduct as defined by the court rule, this court would not be bound by any type of sentencing agreement. That would include the prosecutor's deferred. You understand that, sir?
Yes, Your Honor.
You also would not be entitled to withdraw your plea. You understand that?
Yes, Your Honor.
All right. On the date of November 20th, November 20th, 2024, location of 7,000 East Michigan Avenue. What did you do at the Walmart that makes you think that you're guilty?
We were at the checkout line, and I had scanned some items and then moved some items away to not be scanned purposely. And the
all right, so you were skip scanning?
Yes, Your Honor.
All right. And the amount of the items that you skip scanned Was that in excess of $200?
I believe it was just under 300.
All right, so that's in excess of 200. Okay. You didn't have anybody's permission to do that, did you?
No, Your Honor.
The store was open to the public?
Yes.
All right. And these items that you skip scanned, these were items that were offered for sale by Walmart?
Yes, Your Honor.
All right, counsel, I should first of all ask counsel, are there any other pleas, threats, or inducements that counsel would be aware of that have not been placed on the record that is led to this plea?
No, Your Honor.
No, Your Honor.
Has the court complied with the court rule and would be proper to accept this defendant's plea?
People are satisfied.
Yes, Your Honor.
All right, court will accept the defendant's plea of guilty to this charge. Defendant is referred to probation for a pre-sentence investigation and report. Sentencing in this matter will be
July 30th, 2025 at 12 p.m.
July 30th, 2025. You said 9?
At
12 p.m.
You'll be back, right?
The 29th, correct. I'll be back.
Your Honor, regarding travel, my client's girlfriend, who's actually on your docket in the next block because she's hearing impaired and needs an interpreter, is having a surgery in the state of New York. My client and she would like to travel to New York to have that, and they're staying for extended recovery time with her family in New York. His travel dates are July 3rd, returning July 29th, and he will be here. And I'll try to get his PSI done before that time, or ask if it could be done.
July, when are you leaving?
3rd to the 29th, pardon me.
To the July 29th, and that's to the state of New York.
Yes, Your Honor.
I will allow and give permission for the defendant to travel to the state of New York.
Thank you, Your Honor.
Thank you.
Wait for me outside.
Sure.
Okay.
Bond in this case.
Oh, sorry.
Bond in this case will be set in the amount of a personal recognizance $5,000 bond. I will order standard conditions, including no possession of any weapons and no assaultive behavior. I would also indicate the defendant at this time is not to possess or consume any alcohol, recreational marijuana, or any illegal drug. I would indicate also that he is not to enter any Walmart in the state of Michigan. You understand that, sir?
Yes, Your Honor.
All right. Great. Thank you.
Go ahead. I'm sorry.
Court does call the case of the people versus Ali Hari.
People.
Hari.
Yes, it is. Your Honor, Joe Simon on behalf of Mr. Hari. Go ahead and state your name, Ali.
Ali Hayari, Your Honor.
Okay. All right. What are we doing?
If I can just tell Miss Lundy one quick thing.
Andy and Simon is never a quick conversation. See?
Yes. Thank you. Your Honor, we're requesting the matter be set for final settlement conference.
All right. Jury final settlement conference will be set for August 8th.
Yes.
August 8th, 2025, 9 a.m. Jury selection, if necessary, August 11th, 2025 at 8:30. Both of those proceedings are in person.
Thank you.
Thank you, Your Honor.
Bond will continue.
And
court does call the case of the people versus Natasha Olmos.
Ashley Lonnie for the people.
David I. Goldstein appearing on behalf of the defendant. Ms. Olmos is approaching the podium.
Morning, Natasha Olmos.
Thank you. All right, what are we doing?
Your Honor, I just recently substituted in. Mr. Burdell did provide me with the written discovery, but I understand there are videos, which I do not have. Ms. Londy is going to provide them. I also anticipate a motion to dismiss one of the two, either count 2 or count 3.
Turn this matter out to July 15th, 2025, 9 a.m. I think July 16th, I'm sorry, 2025. 9 a.m.
I figured you said it for the 15th, so I'd be on time for the 16th. but
Yeah, it was a thought.
Conrad Clark.
So I just want to make sure, because we had some complications in this. We have your appearance, however, because there was previous counsel, I do need a substitution. I don't.
I thought we sent one, Your Honor.
Pardon?
Let me look. I thought we sent one.
I have one.
You have the substitution?
Yeah, it should be in there. I'll double check, but I do know I received one.
Oh, wait,
Yeah, his
there it
opinion.
is. There, excuse me. Okay, that's why. Okay, we have it.
All right, thank you, Your Honor.
Court does call the case People versus Kyle Burmeister.
Christina Bergeron for the people.
Okay, Boyd is here.
Assistant Public Defender Natalie Pay on behalf of Mr. Burmeister. I do not know, Your Honor, if he is logged in via Zoom.
I do not have him.
It's my understanding he's still at Oakdale and set to be leaving Oakdale on the 27th of this month. And it was my tardiness. I just provided the Zoom to Oakdale via email yesterday afternoon. I would respectfully request an adjournment. I did reach out to the people in hopes to adjourn this by stipulation as Mr. Burmeister is set in
I'll
front of you.
adjourn it to July 2nd, 2020.
Thank you, Your Honor. That was July 2nd.
Yes.
Okay, perfect. Thank you.
Court calls the case People versus Ashton Ebler.
Assistant Public Defender Natalie Pate with and on behalf of Mr. Keeler, who is present via Zoom. Sir, can you please unmute and state your name for the court?
Ashton Ebler.
Thank you.
Thank you, Your Honor. I have discussed this matter with both my client and the people, and we would respectfully request to set this for a final settlement conference.
And an unregistered trailer.
Yes, excuse me. Yes, Your Honor.
It's my request, Your Honor.
Pardon?
It's my suggestion that we set it for final settlement.
Oh, joy.
I know.
Jury final settlement conference will be set for August 8th, 2025 at 9 a.m. Jury selection if necessary. August 11th, 2025 at 8:30. Both of those proceedings are in person.
Thank you, Your Honor.
Thank you.
Thank you, Your Honor. And thank you, Mr. Ebler.
Thank you.
Thank you, sir. Court does recall the case of the People versus Gabriel Boyd.
Christina Bergeron for the people.
Good morning, Judge Rita Spavich on behalf of Ms. Gabriel Boyd. Judge, thank you so much for passing this on for a little bit. My client has some technical issues this morning.
Okay, not a problem. Ms. Boyd, can you state your name, please?
Gabrielle Boyd.
Thank you. All right, what are we doing?
Judge, I'm respectfully requesting that this matter be scheduled for an evidentiary hearing at the touch base with Ms. Lundy yesterday.
All right, an evidentiary hearing as to what issue?
Judge, I believe I'm going to be filing a motion as to no probable cause to arrest.
All right. And how soon will you get that motion in?
Judge, I can get it done within I fly back home next week, but I can still get it done within the next week. I guess if you would just give me 2 weeks, if it's not too far out. Judge
Okay,
it.
that's fine. We'll do that. So I will indicate that you're to have that by July 2nd.
Okay.
(2025), close of business.
Thank you, Judge.
Prosecutor's response would be due by July 16th. That's close of business. And then I'll set an evidentiary hearing on this matter. Give me my trial week and put it on that.
I'm sorry, you said you want your trial week in July. That would be July 30th at 9 a.m.
And I'm not available on that date. Actually, one of the people, I apologize.
That's that whole week, right? So give me, you're not available that week?
That week or the following week.
Well, that's gonna be a problem. All right. Then what I'll do is I'll set an evidentiary hearing then. If you get it in by the 16th, I'll just have to. July 23rd.
Thank you, Your Honor.
Thank you, Judge.
I don't have that date. I don't have that date? Why? Oh, that's right. I don't have that date. Well, and give me a date I do have that. Apparently I'll have to fit with Miss Lundy's schedule.
Well, it's not just Miss Landy, it's also my schedule as well, Judge, just in her defense, because I'm out of the country.
Oh, you don't have to.
I mean, it's true, Judge, you know?
The afternoon jurisdiction.
Yeah, which would be Monday, the 11th of August.
Okay. Set an evidentiary hearing then, August 11th, 2025 at 1 p.m.
At 1 p.m. Awesome.
Okay.
That works. Thank you, Judge. Thank you so much.
Thank you.
Judge.
All right.
Thank you.
All right. Thank you, ma'am.
Thanks, Lonnie.
Godspeed on your travels back, Counsel.
I appreciate it, Judge. I don't want to leave yet, but gotta come back. So.
Got it.
Thank you, Judge. See you. Bye.
Thank you. Court does call the case, People versus Alexis Berry.
This is an arraignment and pre-trial, Your Honor.
Your name?
Alexis Berry.
All right. You are before the court on a misdemeanor complaint that alleges that on or about April 10th, 2025, at the location of Ellsworth near Stone School Road in Pittsfield Township, Washington County, State of Michigan, that you did operate a motor vehicle while intoxicated. Do you understand the nature of that charge?
Yes, Your Honor.
All right. That is a misdemeanor punishable by up to 93 days in jail and $500 fine plus court costs. The court could order community service or any rehabilitative services the court deems necessary. The court could order your vehicle immobilized, could order you to pay the cost of the prosecution as well as the cost of any emergency governmental services. You understand that?
Yes, Your Honor.
All right. First question I have for you is, do you want to be represented by counsel?
Yes, Your Honor.
All right. It's a public defender case. I think you are represented by the public defender.
Correct, with my previous one, which with you.
Assistant Public Defender Natalie Pate with and on behalf of Alexis Berry, who stands to my right, we would waive any further reading. My client would stand mute and ask that a not guilty plea be entered and ask for an adjourned pretrial date, please.
And in every way, formal reading, standing mute, court will enter a not guilty plea. Pretrial in this matter will be adjourned July 2nd, 2025, 9 a.m. As alleged BAC in this matter.
0.062. Oh, my bad. I apologize.
That's okay. They know.
Your Honor, if I could, the alleged BAC 0.062 and then the 10 nanograms of THC as well.
All right.
There's a prior in 2020. I did want to check with you if you have the updated charging documents indicating that this is the second offense.
I do not. When did you send that in?
We sent that in, I believe, late last week, so they should be coming to you soon.
I don't have the only complaint I have in the file is for OWI first.
Okay, this is the second offense. I believe we have requested an updated charging document to indicate that.
All right, so they'll be sending an amended complaint. Ms. Berry, you understand that?
Yes, I do. My first one was.
Well, I don't want to know that.
I got you.
I just need for you to understand that they're charging you with a second offense.
Yes.
All right, that's going to make this punishable by up to 1 year incarceration and $1,000 fine plus court costs. Everything else is the same. You understand that?
Yes, sir.
All right. Okay, well, we'll await that, I guess. But there was a prior. When did you say the year on that prior was?
2020.
Okay. Was there an accident in this case?
There was a crash into the curb of the scene, resulting in disabling damage to the vehicle, Your Honor. So yes, there was a crash. Considering the crash and the BAC and the prior, we are requesting a scrap this time.
I guess I'm a little bit confused because I've got, when I look at this complaint, I have the location described as Ellsworth and Stone School, but then there is a reference to a Marathon gas station. And if I remember, there's not a Marathon gas station there on Ellsworth and Stone School. There's an almost.
Actually, Your Honor, the defendant was observed by a citizen operating the vehicle at the one location and then followed her to another location where she did crash into the parking lot of the Marathon gas station, is my understanding.
So the observation then took place. I guess I'm just trying to be clear. The observation took place at the Stone School Ellsworth location.
I believe so, Your Honor.
And then followed it all the way to the Marathon gas station. I'm not sure what Marathon gas station I'm talking about because that's.
I thought I had included the address on the complaint, the one on 54970 Washington, Your Honor.
Got it. Okay,
Yeah.
I see. All right. Okay. All right. So there was an accident. All right.
If I may briefly, Your Honor, I would request a PR bond, and I would ask that Alexis Berry not be on a scram tether at this time, given from what I heard, the allegations are that she was intoxicated but under the legal limit and that the allegations were of marijuana. Given that, I would ask that a scram tether not be imposed. I would ask for a PR bond, and I did previously represent Ms. Berry on her previous case, and based on my prior representation of her, I had known her to not be a flight risk and to both come to court and comply with bond. I would ask for a PR bond and standard supervision, but ask that the scram tether not be imposed.
Your other cases are what type of cases are?
Your Honor, that was a DV, and my understanding is, and the people can correct me if I'm wrong, that this charge stems from that same discovery and alleged incident.
Okay. So just so that I'm clear, you can correct me if I'm wrong. The DV incident or alleged DV, that involves the use of alcohol, or alcohol was consumed.
Yes, Your Honor. The allegations were that both cases stemmed from the same day and time and chain of events. So yes, Your
I
Honor.
had two criminal events coming out of what may be the use of alcohol. Is what
Possibly, Your Honor. Yes.
Possibly. All right. Anything from the people?
Yes, Your Honor, I'll just reemphasize that while the blood alcohol level was under the legal limit, the defendant was under the influence of 10 nanograms of THC. There is a prior from DOWI from 2020, and this did involve a crash, and this is why we're requesting a screen.
What I'm going to do is I'm going to set bond at a $10,000 personal recognizance bond. I'm going to order standard conditions, including no assaultive behavior or possession of any weapons. You understand that?
Yes, Your Honor.
There's to be no use of any alcohol, recreational marijuana, or any illegal drugs. I am going to order that the defendant is to report over to the Department of Community Corrections for two things. And that is that she's to report over and be placed on a SoberLink testing device. I'm not sure how long I'll have that last, but I want it on at least at this point in time. And then drug testing 1 time per week. And I will let you know that we can get levels, and the court's expectation is the THC in your system will exist, that will go down and become non-existent. You understand that?
If I may, Your Honor, if Ms. Berry was to have I don't know, I muted that, was to have a valid medical marijuana card and provide the needed documentation to community corrections, would she be able to continue using that as prescribed?
Does she have one now?
I do. I've had it.
I'm gonna have some concerns about that.
I've had it since I was 18, since the 2020 charge. That's what I was trying to say. The 2020 OWI charge is from marijuana, not alcohol.
I'm gonna put her on testing. I've issued my order in terms of bond conditions. I'm not gonna get into an extended argument about of what the court can order regarding medical marijuana. So
just to clear my client
issued my order.
So just so my client understands, Your Honor, no marijuana of any kind is your order at this time?
I've issued my order. I'm not trying to be I've issued my order. Thank you.
Understood, Your Honor. Thank you.
Court does call the case People versus James Bowman. Mr. Bowman? Okay, come on now. Is that her? She's crying. Did I ask you to state your name? I'm sorry.
Oh, no, James Bowman.
Thank you. All right, Mr. Bowen, you are here on a complaint that alleges two charges. And it alleges that on or about July 25th, 2024, the location of State Street near Textile, that you did possess or transport open alcohol in a motor vehicle. That's commonly known as open intoxicants in a motor vehicle. You understand that, sir? Yes?
Yes, sir. Yes, Your Honor. Sorry.
That's a misdemeanor punishable by up to 90 days, $100 fine plus court costs. The court could order community service and any substance abuse screening. You understand that?
Yes, Your Honor.
Count two alleges that on that same date and at that same location, you did operate a motor vehicle without security or insurance as required by statute. Understand that?
Yes, Your Honor.
All right. That's a misdemeanor punishable by not more than 1 year incarceration, not less than $200, nor more than $500 fines plus court costs. You understand that, sir?
Yes, Your Honor.
All right. So the first question I have for you, sir, is do you want to be represented by an attorney?
No. No, Your Honor.
Really? Okay, what do you want to do on this?
This is my first time being in this situation.
Really?
Yeah, I have no idea.
Really? You have no idea?
Yeah.
Don't have a law degree?
No, Your Honor.
Don't know what I might do?
No, Your Honor.
So you don't know what you want to do?
Not really, Your Honor.
No?
I'm sorry.
Okay, so I'll ask the question again. Do you want to be represented by an attorney?
Yes, Your Honor.
Yeah, good choice. All right. It's a public defender case.
Good morning. Assistant Public Defender Lauren Perny on behalf of Mr. Bowman. We would waive formal reading, stand mute to the charges. I request another pretrial date.
All right. Defendant having waived formal reading. Standing be at court will enter a not guilty plea on his behalf. You wouldn't have known to do that either, would you? No, right? You wouldn't have known to do that, right?
I would not have you.
No, okay. All right. I'm just making sure they're helpful for you. I'll adjourn the pretrial to July 2nd, 2025, 9 a.m. Any issues regarding bond?
Your Honor, we just request standard bond conditions in this case.
All right. Ms. Farady, anything?
Your Honor, I'd ask for a personal bond, given his
Would he have known to do that?
No, Your Honor.
Okay, all right, go ahead.
I like being helpful.
All right.
Given his representations that he has no criminal history and these are both they're both misdemeanors.
Yes, they are. All right. I'll set his bond at a $5,000 personal recognizance bond. I'll order standard conditions, including no assault behavior or possession of any weapons. There's to be no use of alcohol, recreational marijuana, or any illegal drug. You understand that, sir?
Yes, Your Honor.
All right. Thank you.
Yeah.
Court does call the case of People versus Alexis Brown.
Right, well, I'll be in touch.
Alexis Brown. You're not here. I will issue an order to show cause. Court does call the case of the people versus Issa Awad.
Absolutely. Your Honor, for the record, I just spoke to Mr. Awad and asked him if he heard from his lawyer and if she was. So those are the only contents of our conversation. He is present.
Mr. Awad is present.
He is.
Where? Oh,
He's
wait.
conveniently hidden by that.
Okay.
That thing.
Yeah. I said he's always appeared. I was
Correct.
like, where is he?
I don't know.
Well, I
if
was
it's-
actually sending people out to find him, but I'm glad he's here.
I don't know what
I'm
the
not-
sport is. I have not heard from her.
Have you heard from your attorney, sir? All right, why don't we, do you have an email for?
I do have an email for her.
All right, why don't we email and try to call, see if they're down. You're welcome, sir. Court does call the case of the people versus Timothy Haslem.
Conrad Siller on behalf of Pittsfield Township.
Christina Bergeron. Good. Sorry. Good morning. This is Nicole Letter on behalf of Mr. Haslett. This facility is not signed. It's in Macomb County.
He's in Macomb County. And they've not signed on. All right, what I will do is I will adjourn all of these matters out to July 2nd. Two thousand 25-90. Is that my next block up there? Or is that-
Yeah, you're done.
This one, were there only two cases on? For Haslem? Is there only two cases on? Okay. Okay, so what I'll do is I'll finished up that block. I'll just push Mr. Watts into the next block while we try to find your turn. Okay, thank you. Court stands in recess.
All rise. May be seated.
Linda Downer.
Thank you.
Your Honor, for arraignment purposes, we would waive reading and stand mute.
And in every way for a reading standing mute, court will enter a not guilty plea.
Your Honor, for pretrial, I inform Mr. Siller, my client is going to just plead guilty to the charge. I'm going to be moving for immediate sentencing, but of course, that's not a part of the plea, and understand that as well.
All right. So she's just going to be pleading.
She is, Your Honor.
This is a 90-day.
Yes.
500. All right. May I have your sworn?
Raise your right hand. Do you solemnly swear to affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
State your name.
Linda Downer.
All right. Ma'am, it is this court's understanding that you are going to be pleading guilty to the charge of open intoxicants in a motor vehicle. Is that correct?
Yes, Your Honor.
That is a misdemeanor, punishable by up to 90 days, $500 fine plus court costs, community service, and any substance abuse treatment the court deems necessary. You understand that?
Yes, Your Honor.
All right. Understanding that, you still wish to plead guilty?
Yes, Your Honor.
All right. And to that charge, how do you plead?
Guilty.
All right. You understand that by pleading guilty, you will not have a trial of any kind.
Yes, Your Honor.
All right. You've signed any advice of rights form today?
Yes, Your Honor.
All right. Any question regarding any of those rights?
No, Your Honor.
Please look at paragraph 5. Those are your rights which are part of a trial. You understand that by pleading guilty, you'll be giving up those rights as well as all the rights on that form.
Yes, Your Honor.
You understand you're giving up your right to appeal of right.
Yes, Your Honor.
Are you on probation or parole?
No.
Has anybody promised you anything other than what's been stated here today on the record to get you to plead?
No, Your Honor.
Anybody threaten you or coerce you?
No, Your Honor.
You're doing this voluntarily
Yes, Your Honor.
of your own free will? And because you believe that you are indeed guilty?
Yes, Your Honor.
All right. On the date of April 24th, 2025, Laurel Road, Pittsfield Township, Washington County, State of Michigan, were you a driver of a motor vehicle?
Was I driving?
Yes.
No,
Well, you drove to Meyer, is that correct? Across the street?
yeah, across the street, yes.
Okay. All right. And were there open intoxicants in your motor vehicle?
Yes, Your Honor.
All right. What were they?
It was some wine that I'd been there for about a week or two.
So it was wine?
Yeah,
That was-
about that much.
How much? That much?
Lighthearted, yeah.
Huh?
Low calorie, low alcohol.
Okay. All right. And it was yours?
From karaoke, yes, Your Honor.
All right. Very good. I do have to advise you, ma'am, that while it may not be applicable in this case, since I'm going to do an immediate sentencing, but if you do commit misconduct, like within the next few minutes, then this court, any evaluation or sentence agreement, the court would not be bound by. You would also not be permitted to withdraw your plea if you do that. You understand that?
I understand that, yeah.
Counsel, have there been any threats, promises, threats, or other inducements which have led to this plea that have not been disclosed?
None from the prosecution. No, Your Honor, thank you.
All right, very good. Counsel, have I complied with the court rule, and would it be proper to accept this defendant's plea?
Yes, Your Honor. Yes, Your Honor.
Court will accept the defendant's plea of guilty to this charge. All right, anything you want to say, or she gets?
Oh, she doesn't look at Your Honor.
Gallery.
Coming up. Is she in the room? Yes, sir. Come up, Mr. Butler. Judge, on this case, no, what kind of papers are they left? You gonna get every day. I'm trying to keep it together. Okay. Yes, I'm done. Yes. Oh, yes, absolutely. Okay. In 25 CR 364, as you know, with part of a 30-day felony harassment of a public servant. So that there's where the 10 years in prison is convicted, very serious. And have you been hired on this? Well, what happened, Judge, in our last court appearance, Ms. Dudley stated that she was going to hire Mr. Galmore, and we gave her time to do so. But from there to now, she's decided in her judgment that she wants to stick with me. So what I'm going to do, so I just want to put it on announcement docket because he's not going to hire Mr. Galmore. Okay, that's right, ma'am. We'll set on the announcement docket. And 4 weeks, good? That's fine. Okay. Just go. Put there, Sonny. She's here as well. Ms. Kubido, come on up.
I'm there.
And this is Ms. Kubido's first appearance on your announcement docket. I did on discovery on this particular case, so I just want to put her on, not announcement, I'm sorry, I misspoke. My first appearance on your initial docket, the initial docket. I did download, discovery and everything with them, so I just want to put her up to the announcement. And we'll be ready to rock and roll. Just put it there. Now that's you, Carol, and then put that, and Mr. Adams, is your thing, fine. You're charged, that you want to make sure that you know that it wasn't conflict, it was 3 indictments in America, speaking of the sentence. It alleges an honor about April 14th, 2024. In Jefferson County, Texas, he committed a second-degree felony on both of a habitation, which carries with it conviction of no less than 2 nor more than 20 years confinement in prison and a fine up to $10,000. 24 CO 1318 and 24 CO 1319 allege state felonies in the case. 1318. It's on about December 7th. As well as just 1319, also alleges that on or about December 7th, 2023, in Jefferson County, Texas, you committed a state jail felony that's of forgery in 1318 and fraudulent use of identifying information. This one, fraudulent information in 1319. Now, these are state jail felonies, which carry over no less than 100 days after 2 years in the state jail. However, it's also alleging you have 5 prior convictions, felony convictions. And what that means would be is this who's the attorney on this one?
That's Mr. Boyd.
Is this enhanced? Their state jail felony, but or is the punishment enhanced to a 3rd degree or a 2nd degree? This one, because it's a 3rd degree, Your Honor. So you are looking at convicted of under the state jail felonies because of the prior criminal convictions here that are alleged, and they're all state jail felonies. But prior convictions catch up with people when you commit another crime later. So you are looking at each of these 2 cases, no less than 2, no more than 10 years confinement to this. So we're looking at a total, and it's all said and done, up to 40 years in prison. Yes, serious for time. I think a little bit is going to be. Mr. Adams is a very good lawyer, will help you navigate through this minefield so that you don't hurt yourself. What are you going to do for them?
This put us from the initial step into the office.
Okay, that's good.
That's perfect. Same with such data as lovely.
Did we send it?
Thank you all. Just meet me outside. Meet me outside.
What's my favorite? I have Yanni, is it Nidveta? Nidveta? And forward. Yanni, Nidveta, not the motion problem. And 25, CR 529, Yanni Daniel Mendieta. There is no answer in the courtroom. I asked if they you're home into the hall, so for Yanni Mendieta. Which is
Oddly, just this. That's what we're looking for?
a bond on Mendieta. So, page 2 of this.
Sorry, I got.
There's no answer here in the courtroom. No answer to the Mendieta's hall out in the hall. The defendant has failed to appear today.
And Your Honor, I believe this is an individual that was here legally. I believe I did deport him a while back when this was from the Jefferson County Jail. Though.
It's a $5,000 cash bond.
Oh, that bond is revoked. No bond is ordered at this time until or unless the defendant gets rearrested. The state of Texas has information that he was deported on immigration and naturalization authorities. Thus, there's a cloud over his legal status to be in the United States. So you have to resolve that. It can be released on bond. So no bond in that case. And all it's Stackery Pool in 2 cases, Stackery Pool That's see you. Picture you. That you can? Yes. The changes. Okay, you were Zachary Leroy Poole. Yes. You were charged here in 2 cases. 23 CR 1044 and 24 CR 169. These 2 indictments. These are both state jail felonies. Could be worse, but they're still felonies. It's a burglary of a building in 1 case. On or about March 21st, 2023, it is alleged the state jail felony of burglary of a building. And then the 2169 case, so this is that on or about August 22nd, you committed this felony of theft of property. Did you tell them about this? This 104, this 23 case is almost 2 years old. You've never been arrested on that? Where is your address still 12480? Yes. How long have you lived there? Your whole life? Very much. They normally, they'll look at that home address first. That's what it's showing. That's been winning. I don't know what happened on that. Anyway, that was, you're looking at up to 2 years in a state jail on case. But she is a felon. So you understand if you work on that, where? I'm in between jobs right now. What pipeline? Are you working or not? No, I'm straight. Okay, is that your final answer? You said yes, you were. 10 seconds ago. Now you're not. I'm starting a new job. Yes. Okay, is it the same kind of job? Yes. Okay. Okay. People sometimes move from one employer to another, but it's a similar job. Yes. It's needed. Yes. Okay. When is that going to start out? Since on Monday. Oh, good. How much do you make an hour? 18. Hello. Yeah. That's about 40 grand, huh? Yes. You're ready. You need to look to get some help on here. We get lawyers to help you. Do you know any? Have you ever had to have a lawyer before? Yeah. Okay. I'm going to give you a few weeks to talk to some people. They got some lawyers here, and it's one of them. Could help you, but it's your fault. You get the advice. But you need to hire somebody. I'm going to give you 3 weeks to talk to some people, to some that you get hired. You might not have to be back. Your lawyer can take care of that next court date without you being here. But nonetheless, still has to have a lawyer along the way. If you don't have it, come back there, but you will figure out where you are at that time. The first thing is you're on a bond, right? Yes, sir. Yeah, the first thing in the bond is don't commit another offense. Yes, sir. Don't make a mistake like that. That's your bond and you're stuck in jail. Yes, sir. And sometimes that takes a long time, so it gets wrong. Yes, sir. You're gonna get a resetting from this nice lady. If you hire somebody, make sure they got that reset, so they know when they're gonna have you back. Yes, sir. Hey, come on, back. We'll figure it out. Yes, sir. This, and another thing, don't do this again. Yes, sir. Right? Yes, sir. You learned a lesson, I hope. Okay.
Somehow that is.
Yes. We'll try and extend the basis. When cases.
Yeah.
Okay, I have a case on Nestor Road, but it says dismissed, question mark. Is it?
Yes, Your Honor, that was
Okay.
dismissed.
Okay. Got on, do I need to sign that or?
Did you submit it yet?
Yeah, I believe that was a while back.
Okay, Ruben Cartwright. I don't see Mr. Cartwright. William Patio. Are you here, Mr. Patio? Padillo? William Carter Padilla. Okay, that's a 9:30 docket, so.
Yes, sir.
I'm trying to jump ahead to see if somebody might be here. Is Mr. Doyle not going to be here today?
He called in ill.
Mr. Linder, Donnie Linder, are you here?
Yes.
Okay, your attorney called in sick. Okay, so we're gonna have to reset it.
Yes, sir. I've been trying to call him and I couldn't get him.
Must be sick?
Sorry.
I think he's sick.
Okay.
And hopefully he'll be back on his feet soon, but I can't go without him.
Yes, sir.
Okay. So we're gonna reset it about 2 weeks. Okay.
Yes.
Yes, sir. And is Dustin here? Got one? Gregorio Flores, are you here?
Yes, sir.
Have you seen your attorney today?
No, I have a 9:30 office as well.
Hey, Daniel.
There's a lot of times the lawyers are here early. They got nothing else to do.
That was on May the 20th.
They're all.
Probably not a free.
Rachel Fuller.
This morning.
He said he had wouldn't be up here. He just might be later. Just do it again.
Hey, Ryan, Jarvis.
Yeah, I just asked the shirt.
They say he's middle of where.
Yes, okay. Okay, that sounds good.
Thank you.
Okay,
On this 9:30.
here, I'll give you half. Well, let me pull Linda.
And what? Where'd you get that time? It's not mine. It's not.
But actually, involved.
What's the name on the back?
I don't like the play.
What's the name of the time?
Not pretty much. That's probably the bills.
Yeah, you're doing better.
Or very far. It's so.
I'll take care of it. Don't worry about it. You can trust the ex-wife to get at least if I get my side.
Yeah.
Okay. Done one of y'all, that's the best. What are you gonna do here?
I UCL, but I'd probably do probation if we play the group that they enhance. I think.
Marvin?
Yes, sir.
Dylan Woodson?
Yes, sir. Just making it easy.
You certainly, must be. What are you gonna do then?
Just issues, the media that we're doing on that. Last minute, he wanted to finish.
Okay, what, like 3 weeks ago?
3 weeks is just even.
One was asking about. What you want? No.
Sure.
I told him about the stag that he was living in the fall.
Wilson?
Yeah.
Wow, you know what you said before?
He said. Sorry, those sheets at heels and then information. Everybody got jokes today. I'm very guilty. Where sounds.
The next one, we shoot someone.
Oh, you gave us. Why does that make a difference?
Thank you.
No, something, that was the wrong one. I just gave you that.
Oh, yeah, that's full.
Really bad shot. His gun pulls to the left.
Mr. Rolfs is your attorney, and what are we gonna do with this? These
Two cases, Judge. I'm asking for one more announcement, Judge. Mr. Larry gave me an offer this morning. It's a cap off. I'd like some time to go over that with
How much time do you need? 4 weeks?
4 weeks of the
It's
committee.
done. I have, on Arlen's case, Deontay, the case is reset.
Correct. This, Autumn has one more case, Judge.
And then, what is that?
It was just in here.
is fine, Judge. Okay, Justin Lee Young, that was reset, that was Bruce Smith's case.
Yes, sir. He's still out ill.
Are you? Okay. I'm looking at this. This says it's reset, so I don't know what happened on that.
Mr. Smith is still ill.
Okay, the attorney's ill and we're gonna, yes, sir. Thank you.
We've already sent the reset to you. Yeah.
All right. Or did you give him a date?
We sent it to his attorney already, guys.
Now. Reagan, we've got several cases. You want me to wait for you to do whatever it is you're doing? Do I have all phone?
Nope, I've got them right here. These are all the Spinaldi's.
Oh, man. 100. Mr. Noah? Yes, sir. That's you? Okay. And in the 24 sequence, 2031, you talked about the second degree felony of assault on a peace officer, which carries with it up to 20 years in prison. So deal with it responsibly and seriously. What are you gonna do there?
Judge, I have submitted a tape request, but I'm still waiting on that to be fulfilled. I'm still waiting on the media and then I need both of us to watch that media.
How long has it been requested?
I'm not sure. I know my office resubmitted one Monday, I believe, but I'm not sure if there was one on file before that. It is likely an issue on my end.
How much time?
4 weeks to be fair, Judge.
Okay. All right, we said.
I need both of us to watch that media.
How long has it?
Still waiting on the media and then I need
How much time?
4 weeks to be fair, Judge.
Okay. All right, we said. Mario Cantu? Mr. Cantu?
Let me get a full face, Judge. I need to speak with him.
Like that.
Okay. Mr. Cantu, just have a seat. She's gonna talk to you about some things. Jocelyn with Colton? Colin? Jocelyn with. Yeah, fine. Okay, you're charged with third degree felony of unlawful possession of a firearm by a felon. Carries with it up to 10 years in prison. Curious. Okay.
I'm still waiting for the portal discovery and the media discovery associated with this case. I have requested both.
I know.
I'm taking care of that right now, Judge.
We're working on it, Judge. I think it'll be 4 weeks to give us time for both of us to watch the media and decide how to proceed.
Okay.
Thank you, Judge.
Jared Edwards. All of it is the same thing, or,
Yes, this one is busy. I have discovered on him, but I need him to come into my office to watch it.
7 months old.
I'm Judge.
We're just, what's that?
No, I haven't discovered anything to come to my office to watch these discoveries so that we can make a decision moving forward.
I'm not fine.
4 weeks, please.
Everything, I'm gonna, fine. Magdalene, right? Magdalene or Magdalene, okay? 25 CR 71, no answer.
It's not on the holiday index.
Off to this direction. Is it female or male?
He was here for her initial appearance with me
When?
3 weeks ago.
Oh, okay, not today.
No, not today. I do have an offer on my face, but I'm still waiting on the meeting.
Magdalene 25 CR 71, there's no answer in the courtroom. I asked the baby to call into the hall and Magdalene, right? Yeah, so. What number?
Magdalene.
Okay, how much time do you say?
4 weeks, Judge.
You said 4 weeks, then 4 weeks, please. You know. Issue green.
Yes.
Great. All day. Who's the prosecutor?
It's Dan.
Okay, then nobody else on this one, okay? It looks like in the indictment, this states it's a 3rd-degree felony. It alleges that he was finally convicted of the felony of illegal possession of controlled substance in 2001. Of a Kappa shooting, arrow. And then you were also finally convicted of extradition status in 2012. He's in the 15th district court was in the land together. So, okay, paragraph 2. That's felony. This also says a felony. Are those sequential?
No, Your Honor. They're not, but I think there may be a
One's 2001 conviction and the other is a 2012. Unless you use the same.
We're trying to figure that out. It's my understanding the way that it's put in the indictment currently, it's enhanceable to a 2nd-degree felony range for punishment. But Mr. Boyd thinks that there might be another way for it to be enhanced to a habitual status.
Which would be no less than 25 to life.
That's correct.
But she's got a prior conviction.
She has at least one that can be.
You can't get a probation from a jury if you're found guilty. So.
And I've talked to her about all of those options.
Everybody's got free will, and we'll move. Is this succinct? Is this one kind of straightforward, or is it complex? I didn't ask you.
Well, there's going to be there will be a few witnesses on it. We'll have a few witnesses from here as well as potentially from Louisiana. So we'll have to just cross the border. So it'll be.
It's a good sign that I'm like, when you live.
Am I gonna look into on these fires?
Yes, sir.
Yeah,
no, you
whether they kill or not.
Yes, sir.
Okay, but it's set to 5, okay?
I understand. I have explained to her that she can request a new attorney if it's moving to the trial docket. I'm just not sure of her preference on keeping me or requesting somebody else.
She really doesn't get a choice. I mean, it's true. It's circumstantial based. Also, I actually represent, and that's not just that's not the test. It's for sure. She doesn't get, she can hire anybody she wants. But if you're unable to hire somebody, the court appointed is who it is. You get a competent lawyer by, and it's paid by the taxpayers. And that's why you just don't get that.
You know, to say.
Decide. You're gonna interrupt?
No.
Yeah, it's, it can, might, indeed go quicker to the job if she were released. And we have a group of people who are ready, willing, and able to try the case. And that would be a reason that the court would allow, which is the main reason, we allow the public defenders to yield if that is what you would prefer. Is that what you would prefer? Get it quicker? Get it through this? You want to get it through quicker? Just to trial quicker? So is that what you want? Okay, you want that?
No, she says she wants it.
Oh, okay, it's still gonna look quick.
That's fine.
What's that? Pretty quick. Okay. And no BS, okay, on this one. That's the, my button here. So next is the Sylvia Party. Get a reset. 24 CR 2325 or is that?
It's great. It's not right there on the highlighted X. I've requested, I'm working on it, and I apologize. I have 4 weeks on hand.
All right, reset.
Thank you, Judge.
Benjamin Johnson.
Chris, I'm hoping you can read it. I'll have to wait my report.
Ronnie Palmore. Yeah, you'll have a seat. She's going to talk to you about some more things on their case. Ronnie Palmore is called next. About page from
Harvey.
Name really man. When you talk to the bond, who got this advice, I think. Oh, Ronnie Palmore, there is no answer to the court. I asked the bailiff to call into the hall for Ronnie where Palmore. It's Ronnie and Palmore.
When they know, like I said.
This is cause number 240525.
Bring them up. But people still know.
No, it's for everyone. Sorry.
Thank you.
Not your. Oh.
Yeah.
No, I got 2 cases here.
Yeah, sure.
And 24CO1555 and 24CO1556.
They're 3 hours.
I'm off the production.
They don't like I said, they don't. I don't, being a supervisor.
You need to be in here. Ronnie Palmore?
Yes, I'll be right.
You need to be in here. This is where we're calling the case. We know, you can go out to get you. It's 9:30. You were supposed to be here 5 minutes ago inside the room.
Oh, I've been outside.
I don't care. Well, I'm not gonna go get you. I'm not, you gotta be in here. We call you here. We do a service by going out and calling the name, but we don't necessarily have to do that. Then you lose your bonds and then a one station. Really deep into it. The charge used to say these offenses 1525 and 1586 with the 3rd degree felony of unlawful possession of a firearm by a felon. And second, paragraph 2 goes on to allege that you were convicted in 2008, failure to register as a sex offender out of Collin County. After that conviction became final, you committed a felony of failing to register as a sex offender and were convicted of that in the criminal district court in Dallas County. So this 3rd degree felony of unlawful possession of a firearm, if all of this is true, you were looking at a minimum 25 years to life in prison on that one case. Next, and then 24/01526, you charged with or about where you saw the same date as the unlawful possession, committing the offense of illegal possession of a controlled substance, namely cocaine. And there are 3 prior convictions alleged in paragraphs 2, 3, and 4, and they are essentially the same convictions that are listed in parts of the earlier indictment I just read to you. So if all of this true on this second degree felony, which would carry with it up to 20 years in prison, this becomes a habitual felon status. You're looking at a second case of no less than 25 years up to life in prison. So that's a minimum of 50 years in prison if you're convicted of both. 25 on one. Life is the high end on each of those 2. Do I need to tell you this is as serious as it gets? All right, it's his bonds. Pulls. What are we going to do today?
We have, Mr. Boardman have been looking over discovery and we're trying to get our hands on or see if a cell phone dump exists within that discovery. He has not been able to reach out to the department to confirm whether that exists or not. So we're waiting to see if that discovery is available to us.
He's out working on a hearing for this afternoon. That's why I'm standing in. Sorry. Mr. Boyd is out working on a hearing for this afternoon. He's trying to get witnesses. So
there's
The bonds are 20,000 on the unlawful possession and 30,000 on the possession of controlled substance.
Say that again.
$20,000 bond on the unlawful possession of a firearm.
Okay, hold on. Okay. Okay.
And $30,000 on the possession of a controlled substance.
I'm looking at a 35.
Yeah. And double then.
Oh, is that what it is?
Habitual status.
Okay.
So they have already been upped to accommodate the habitual status the last time that we were here. He also has a GPS device that he has been maintaining.
That's correct, Your Honor. He was ordered to home confinement and GPS.
In my mind, but man. These bonds were 6/23. And apparently what we could figure out was the justice didn't know about the prior convictions because those weren't indicted. He was arrested.
Yes.
And then the indictment doesn't come out until July of 2024. This bond was 1/6/23. Yeah, it was a year and a half to indict it.
Okay, sorry. That's
That's so weird. Okay. Okay. No.
We're still waiting to figure out if that discovery exists in terms of the phone dump. So if we get, how many weeks?
How much time is you think?
Say 3 or 4, Your Honor, just to give us time to get it from the PD and then make sure that the defense has it. Because it's going to be a large volume of information. The phone dump is.
Okay. Okay. And that's what, was it 4 weeks? Okay, get a resetting and you need to take a seat before you leave.
He's going to give you.
Ron Pelmo.
I'm up here on the highlight events. And then I'll have an update on those 2 that we have.
Okay.
Okay. Mr. Johnson. Mr. Cantu.
Yeah, Mario Cantu.
He's one I need to talk to, Judge. I'll have an update on him soon. Thank you.
John, West, Audwin, what do we need, from you?
Yeah, the fair's open now, but you're sitting for trial.
Huh? Say that again. Who is it?
Mark Cooper, he's present. That's not bad.
Yes, I did.
Oh, he's present. Actually.
Who's on the Sunday? In these two cases, the defendant is charged with aggravated assault with a deadly weapon. In one case, a second-degree felony, and in 1332, deadly conduct discharge of a firearm. Are you still at 3872, Bella? Yeah, speak out. Yeah, okay. You're setting it for trial, right? Which means, have you talked to the victims here on this, how, you know what's happening? You know what happens, I guess.
I think they're setting it for trial because I've offered something extremely high.
The complainants are still on board.
Yeah, she was shot 8 times. She's definitely on board.
Okay. All right. Set it for trial. Saying, he's, there's no prior convictions here, right? I don't see any alleged. Okay.
I don't know how I know.
John West? Right, Kimler? You're working on something? Okay, right, thanks. Who is it?
So George Hardland.
Okay, Mr. Hardland.
Yeah.
All right. Right.
You remember we brunch?
Way dark.
Was it a bubblehead bee?
Yeah, that's what they say.
What's on
bubblehead?
Oh, where that gray is, so that's got the wrong, it must be the wrong bobblehead they got. It's got gray on that.
No, we have one on the docket, Judge. We have a Gregorio Flores.
Yeah. Yeah. Gregorio, come forward.
75 years young. As you've heard the facts of the case, I would respectfully request a fine.
Ma'am, anything you want to say?
Yes, thank you, Your Honor. I mean, no.
It's okay.
No, I don't.
Sentence of the court, fines and costs of $250. When can you get that paid, ma'am?
Today.
Thank you. Take 250 today, also spend 90 days in jail.
Right. Thank you very much. Your Honor.
Thank you, Your Honor. Okay, thank you.
Let's call the case, People versus Kamara Reed.
Ashley Lonnie for the people.
Morning again, Your Honor. Dan Guerin on behalf of Kamara Reed. She's stepping forward.
Go ahead.
Your Honor, Ms. Reed is here, I believe for a pretrial and a bond violation. In however order Your Honor would like to proceed, she will be admitting to the bond violation and then ultimately pleading guilty as charged. So however Your Honor would like to approach that.
Well, she's admitting to the violation.
She is, Your Honor.
All right. Is that correct, ma'am? Yes.
Yes.
Yes. Thank you. All right. All right. And what are we doing on the case?
She's pleading as charged, Your Honor.
She's pleading.
Yes.
As charged. May I have her sworn?
Raise your right hand. You solemnly swear to affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God.
Yes.
State your name.
Tamara Reed.
All right. Ms. Reed, it is this court's understanding that you are going to be pleading guilty to the charge of operating while intoxicated. Is that correct?
Yes.
That is a misdemeanor punishable by up to 93 days in jail, $500 fine plus court costs. Understand that?
Yes.
The court could also order any community service or rehabilitative services the court deems necessary. The court could order your vehicle immobilized, could order you to pay the costs of the prosecution as well as the cost of any emergency governmental services. You understand that? Yes.
Yes.
All right. Still wish to plead guilty?
Yes.
And to that charge, how do you plead?
Guilty.
Now, you understand that by pleading guilty, you will not have a trial of any kind.
Yes.
You signed an advice of rights form?
She didn't, Your Honor, because she's in custody. I could have her do that now, or we could do that verbally, however you prefer.
Okay. You recall signing an advice of rights form, ma'am?
Yes.
Any questions regarding any of those rights?
No.
You'll see on the podium, I need you to look at paragraph 5. Those are your rights which are part of a trial. You understand that by pleading guilty, you'll be giving up those rights as well as all the rights on that.
Yes.
You understand you're giving up your right to appeal of right?
Yes.
Are you on probation or parole?
No.
Has anybody promised you anything other than what's been stated here today to get you to plead?
No.
Anybody threaten you or coerce you?
No.
You're doing this voluntarily
Yes.
of your own free will?
Yes.
And because you believe that you are indeed guilty of this offense?
Yes.
November 27, 2024, location of Carpenter near Chester Drive in Pittsfield Township, Washtenaw County, State of Michigan. Were you operating a motor vehicle?
Yes.
Prior to operating that motor vehicle, did you consume intoxicating?
Yes.
What did you have and how much?
I had a couple of seltzers.
Seltzers? All right. Were you stopped by the police or was there an accident?
I was stopped by the police.
Why'd they stop you?
My lights were off.
All right. Were you ultimately arrested?
Yes.
Were you taken to the station?
Yes.
Was there a blood draw or a blood test?
Both.
Blood draw?
Yes.
All right. What were the results of that blood draw?
I would stipulate for the plea, it was a 0.09 blood test.
You have any reason to dispute those blood test results?
No.
No? All right. I do have to advise you that if I do accept your plea, if you commit misconduct between the time of my acceptance of the plea and the time of sentencing, that any evaluation or sentence agreement, the court would not be bound by. You understand that?
Yes.
I also would have to indicate that if you do commit misconduct during that period, you would also not be entitled to withdraw your plea. You understand that?
Yes.
Counsel, I guess the first question is, have there been any promises, threats, or other inducements which have led to this plea which have not been stated on the record?
No, Your Honor.
No, Your Honor.
And has the court complied with the court rule, and would it be proper to accept this defendant's plea?
Your Honor, I would say for the record, just so it's clear, the stop happened just after midnight. So the stop for no headlights, I think, is a valid stop. I think we stipulate that it was dark outside. Other than that, I'm satisfied.
We're satisfied as well, Your Honor.
All right. Court will accept the defendant's plea of guilty to this charge. Defendant is referred to Von Swartz for an alcohol screening and assessment and the victim's impact panel. Sentencing in this matter will be July 9th, 2025. At what time? 9 a.m. All right. Either as to bond, but as to the violation.
The violation first, Your Honor, my client would waive her right to a hearing and be prepared to admit to drinking and ready to do that this morning.
All right. And that is correct, ma'am?
Yes.
You're waiving your right to a hearing?
Yes.
And you do admit, have you seen the violation report, ma'am?
No.
Okay. Your counsel went through it with you, however?
Yes.
All right. And that there were on June 13, 2025, that you were drinking?
Yes.
Very good. Court will accept that admission. How long have you been in?
She turned herself in yesterday morning. Is that what time yesterday?
8 a.m.
8 a.m. yesterday morning.
All right. How old are you, young man?
20,
How old are you?
21.
Where were you drinking?
Um, sorry. My dad passed away a couple years ago. My dad passed away a couple years ago, and I'm not handling it probably in the best way.
So you were 19,
18.
18 when he passed away.
Yeah.
Let me ask you this, was that where your drinking started, or?
Yes.
And let me ask you this, I'm not gonna hold it against you, were you drinking a lot?
Yes.
Looking back on it, when you were drinking a lot, what do you think would happen for you? Probably don't know how to answer that question. I mean, that's a tough question, isn't it? Suffice it to say, young lady, it would kind of make you forget and have the pain go away a little bit, right?
Yeah.
Okay. So, are you in school?
Yes. I'm supposed to go back next semester.
Did you finish up this semester?
No.
What happened?
I stopped attending my classes, so I had to withdraw.
Where were you in school?
It's my sophomore year.
At what school?
Eastern Michigan.
So when your dad passed away, had you already enrolled in school?
Yes.
And you made it through how many semesters after that?
2, and then I took a gap year, and then I went back.
Those 2 semesters that you took, how were your grades?
They were pretty good. I think I had a 3.2, 3.5.
Okay. You took the gap year, then you came back. How were your grades?
Okay, I think I had like a 2.
Pardon?
I think I had a 2.8 when I came back.
Where'd you graduate high school?
Canton High School.
Okay. Did you do well there? You got siblings?
I have a twin brother.
You have a twin brother?
Yep.
Okay. What?
It's with mom in the corner of the courtroom.
Mom's on? Oh, okay. All right. So what do you think I should do with you? Well, before you answer that, let me ask you this. As you were going along struggling, trying to deal with your father's passing and things, did you let your mom know?
A little, but.
Pardon?
A little, but not as serious as it had gotten, I don't think.
What about your brother?
I think he noticed.
You think he noticed?
Yeah.
Probably because he's your brother and also a twin, he probably did, probably felt it. Did you reach out to anybody?
I've been seeing a therapist weekly.
You were?
Yes.
Okay, so how long have you been doing that?
I was seeing one I've been seeing her for like 7 years, and then I've been seeing one who specializes in grief for the last 3 months, I think.
Okay, so something that you started heading in that direction, dealing with her. Okay. How's that working for you?
It's going okay. I think I've been thinking about seeing someone else.
Pardon?
I've been thinking about seeing someone else. I don't know if it's a good fit.
Okay, so your therapist might not be fitting with you, right? Okay. All right. Now I'll get back to you. What do you think I ought to do with you?
Sure, I guess whatever punishment fits.
Give you a chance to prove you can stay sober.
Yeah. A chance to prove I could stay sober, I think.
You think you can?
Yes.
That wasn't real confident the way you said that.
I want to, and I think that I can.
Young lady, why do you think I asked you all of those questions?
See why I did it, I guess.
Yeah, maybe. Here's the thing that you don't understand and are just beginning to kind of explore. Grief is a horrible thing in a lot of ways. It becomes real bad if you don't deal with it. It kind of just sits there, and then at some point, while you try to sort of bottle it up and push it down, it somehow or another just all of a sudden begins to explode. Right? And then at some point, because you're not dealing with it, you're kind of out of control. And then it becomes harder. At the beginning, you probably could have told somebody, but by that time, you don't tell anybody because it becomes hard to explain. Right? And it becomes real difficult to, no matter how close somebody is, even talk to anybody because you don't know if they're going to listen or they're going to take time to listen. And the reality of all of that is what you want is you just want that hurt and other things to disappear. Right? Were you close to your dad?
Yeah.
I'm gonna guess, but I know I'm right because I'm always right. But I'm gonna guess that you were a daddy's. All right. Look, more than anything, and I'm going to tell you, I don't always talk about myself, but I'm going to tell you why I asked the question. here I sit all these years later. I lost my dad when I was 16. So when I'm asking you those questions about grief, I get it. Okay. I'm going to let you know that if you find a way to kind of deal with it, you're going to make it through it. Okay. I didn't know your dad, but I can almost bet that he'd want you to make it through. He wouldn't want you trying to do this, trying to deal with all of this on your own. Okay. So in the interim, how am I going to keep you sober? Young lady, there's just right now, and partially because of the age you are, partially because of what you've been dealing with, a lot of things in life are real confusing right now, right? You're not sure the next step that you're taking, what direction that's going to head or what you're going to do, right? Okay, here's a suggestion I'm going to make to you. I want you to take whatever steps you're taking slow. I'm watching your mother over there. She's goosenecking trying to look over Miss Pilara's head, but your brother has been right all up in it. Okay. What that tells me is you got a family out there that'll just love you, they'll support you. And if you hadn't told them, probably after today, they'll sit for whatever time and just listen to you. Okay. And as you let it pour out to them, and I'm going to tell you, it's going to come out wrong. It's going to come out crazy. You may think yourselves crazy as it's coming out, but just let it come out. Okay. Said she turned herself in yesterday.
Yesterday morning, yeah.
Here's what I'm going to do. I indicated defendant is admitted to violation. I don't think it does any good to keep you incarcerated at all. All right. So I'm going to sentence you on that violation to 2 days in jail, credit 2 days use. I'm going to let you go. I am going to, however, order that you report over to the Department of Community Corrections. We're going to put a scram tether on you. Okay? You got that?
Yes.
All right. You are going back to school in the fall. That might have sounded like a question. It wasn't. Okay. And that you can take that as an order. You're going to go back. You're going to just sort of walk that journey through life and do that. Okay. You hear me?
Yes.
Okay. And I'll sign that scram order and we'll get you over there. All right, young lady.
Thank you.
Thank you, Your Honor.
Well, you're welcome. And most importantly, sometimes what you just have to do, you just have to be kind to yourself. Okay,
Okay.
got it?
Yes. Thank you.
All right. Take care.
Thank you, Your Honor.
Thank you.
You. Mom, guys, take care of yourselves. I don't know if you heard that, but she's getting out today. You're welcome. You're welcome. Court does call the case People versus Tasha Beavers.
All right, so on behalf of Steel Township.
Good morning, Assistant Public Defender Lauren Perny on behalf of Ms. Beavers. Who's approaching Ms. Beavers? Please state your name for the record.
Tasha Beavers. All right.
Your Honor, we are requesting an adjournment. Ms. Beavers is enrolled in treatment at Home of New Vision. The resolution on this case basically depends on her completing or substantially completing a portion of treatment. So I just asked for a lengthy adjournment so she can kind of get in and start.
Was she at home now?
So I've never seen this. I was explaining this to Ms. Beavers. She was released from the jail yesterday to Home of New Vision. They said she wasn't eligible for inpatient and told her she can do outpatient. So I know Your Honor ordered her to do inpatient, but they told her she can't, essentially. So I've never seen that, because typically if Your Honor orders inpatient, but they did do an assessment. And I did review that with Ms. Beavers. It's pretty lengthy. It's like 30 pages or something. And I guess that's what she assessed her for. So, but she is enrolled and she'll be going 2 to 3 times a week at Home of New Vision.
All right. Any objection to the adjournment?
No, Your Honor. Ms. Pilara just handed me an email from Home of New Vision.
Yes.
It said that Ms. Beavers did not meet the criteria.
Correct. And was discharged to home. Okay, and that's for outpatient
Okay.
treatment. All right. So what I will do is I'll adjourn this then, so we can figure out. I'll adjourn this to July 16th. And then I'd like a report as to where she is.
Sure.
Okay. All right. Her bond will continue at this point.
Thank you.
Thank you. Court does call the case of the People versus Jacqueline Murray.
Conrad Silver on behalf of Steel Township.
Angela, People, Michigan.
Roulette on behalf of Ms. Murray.
Sorry about that, Your Honor. Assistant Public Defender Natalie Pate on behalf of Ms. Murray, and the case ending in 1190 and anticipating appointment on the case ending 0617.
Your name?
Jacqueline Murray.
All right. I'll start with the new case, 0617. Ma'am, you are before the court on a misdemeanor complaint that alleges that on or about May 14, 2025, you were in possession of drug paraphernalia at the location of Harper Road in Pittsfield Township. You understand the nature of that charge, ma'am?
I understand.
All right. It's a misdemeanor punishable by up to 90 days, $500 fine plus court costs. You understand that? Yes?
Yes.
All right. Do you wish to be represented by an attorney?
Yeah.
Public defender case.
Thank you, Your Honor. Assistant Public Defender Natalie Pate again on behalf of Ms. Murray. We would waive any further reading, stand mute, and not ask for a bond at this time, Your Honor. I believe this case will be resolved today.
All right. All right. So what are we doing?
So as to my 2 cases, Your Honor, Mr. Siller has extended an offer in which Ms. Murray was offered to admit responsibility to double parking in the case ending in 1190. And in exchange, the misdemeanor would be dismissed, and that then case ending in 0617 would be dismissed in its entirety. I did discuss that with Ms. Murray, and she would like to accept that offer today.
That is correct, Your Honor.
And what are we doing on the other case?
Your Honor, we are just asking for an adjournment. The people and I are trying to work out a global resolution involving some cases in some other courts.
That's
So we're asking
correct.
for an
There's a
adjournment.
pending retail fraud as well on 15th. So we're trying to see how it's all going to shake.
And when is that one set for?
I don't recall.
I have to, let me look it up. I don't have it.
I think it's the middle of next month, but I'll know here in a second.
I've got it right here.
Retail fraud is set for retrial on June 26th.
Oh,
June 26th.
26th. Okay, so
All right.
next week.
So would it still give you enough time if I set this for July 2nd?
I think so, Your Honor.
I'll adjourn this matter then, that being the case ending in 13/60, July 2nd, 2025, 9 a.m.
Thanks, Judge.
Bond will continue on that case. In the other case, Ms. Murray, do you admit responsibility to the fact that on or about August 2nd, 2022, at location on Washington Avenue in Pittsfield Township, Washington County, state of Michigan, that you double parked a motor vehicle?
Yes.
All right, court will accept that admission. That is in case 1190. That's count 2. Count 1 is dismissed. And also case 167, ending in 167, is also dismissed.
It's 0617.
0617. What did I say? Yeah. Okay. Is dismissed. On the double parking, fines and cost of $180. You're incarcerated. What I'll make that do is I'll make that do 90 days after release.
Thank you, Your Honor.
All right.
Thank you.
Judge.
Court calls case People versus Nadia Costley.
Right, so around, yeah.
Echelon for the people.
Assistant Public Defender Natalie Pate with and on behalf of Ms. Causley, who should be present via Zoom, standing in for Ms. Perny.
She's not. Both are on, correct? She's not in Zoom.
So, Your Honor, for the record, I'd respectfully request an adjournment. It's my understanding that she has a Secretary of State appointment scheduled for today after court. I don't have a further explanation for her failure to appear and respectfully request an adjournment.
In these matters, bench warrant will issue for defendant's failure to appear. Bond in each case is set in amount of $5,000. Will give a 10% privilege. Both of those warrants will issue immediately.
Thank you, Your Honor.
Thank you, Your Honor.
Court does call the case People versus Caitlin Morgan.
Echelon for the people.
Good morning, Assistant Public Defender Lauren Perry on behalf of Miss Morgan, who is approaching.
Your name?
Caitlin Morgan.
All right. This is special time set for sentencing in this case.
Yes, Your Honor.
You know, we did review the pre-sentence report. We have no material changes, additions, or deletions. I did review the recommendation with Ms. Morgan and we do ask that you adopt it, and I would like to make a few statements on Ms. Morgan's behalf when appropriate.
All right. Just so that we're also clear, did you review, there was a victim's impact letter that was sent. Were you able to review that also, counsel?
Yes, I think there were two original, and then I got an initial one this morning, and I was provided that from the victim's advocate.
All right, very good. And I know that the victim in this case is present. My understanding is she at one point wanted to make a statement. I don't know if this letter is.
Your Honor, I believe that provided she just decided to provide you the statement in writing, so she can.
All right.
That's the understanding of the people as well, Your Honor.
All right, go ahead.
Your Honor, today is a special time for sentencing, and I want to start out by thanking Your Honor, as well as Ms. Pilara, and considering some additional information that I provided to her. It was a 22-page memo, so it was quite lengthy. And again, I do thank her for considering this information. I did want to, again, there was a lot of stuff that's provided on the record, and I do want to focus on some mitigating information on behalf of Ms. Morgan. In December, I first want to address her health. In December 2024, she got into a very serious car accident. She's in the hospital for some time and is still dealing with those repercussions. She's seeing both a neurological doctor for the effects of her nerve damage, and she's had one surgery on her arm and is scheduled to get an additional surgery on that arm. It's not functioning properly, her arm. She does not have full range of motion. She did miss a post-op appointment while she was in custody. And when she gets out of custody, she'll be returning to see that doctor. She is trying to get disability because of that injury, and is engaged in another civil suit because of the crash. Even though she is having that difficulty with her arm, she is working and engaged in school. This semester she was at Ross Medical Center studying to be a certified medical assistant. Her plan is to go to nursing school. She was working as a home health aide, for an elderly man. Her mother explained to me that she was essentially doing this job with one working arm, but needs to support her children and assist with the man's daily tasks. She is planning on, or is set to graduate from Ross Medical Center with her certification as a certified medical assistant. However, there's one last test she has to take that includes CPR, and because of her arm, she can't do that CPR portion of the test. She is engaged in mental health treatment. She has a psychiatrist that she sees monthly, and she's also engaged with who she's also engaged with talk therapy with. She does have the support of her family. I have been in communication over the last couple of weeks with her mom every couple of days. Her mother submitted a letter on her behalf, as well as her grandparents. Because of her injury, she does need a caretaker. She is moving in with her mother, so her mother can help her with her own daily tasks, as well as the care of her children. She has 3 children, 7, 2, and 1. Her oldest father died when he was young. So she's desperate to, get out of custody and get back to. Oh, she said he died when she was pregnant with the oldest. Given all of this, her engagement in mental health services, her physical health condition, her children, schooling, employment, I am asking the court to adopt this recommendation. She does have the support of her mother, who is here, and I think would like to speak to your honor. I've had multiple conversations with Morgan over the last couple of weeks, and I think she's quite desperate to change her life. She's already made some changes in the relationships in her life, and I think she's dedicated to the betterment of herself and her children's lives.
All right, very good. Her mother wanted to address the court.
Yes, if that's okay with your honor.
Where is she? Come on now. Hello.
Hi, Your Honor.
What's
If I
your
may,
name?
just one moment, your honor. It's okay.
I'll try.
All right. Your name?
April Moylan.
All right. Go ahead. What would you like to tell?
Your Honor, I'd like to tell you that Caitlin is a good person. She has a good heart. She's active. We are active in 2 churches. We go monthly, feed the homeless down in Cass Park. As a matter of fact, a month before Caitlin's bad accident, we were down in Cass Park handing out hot meals, essentials, clothing, whatever we could do to help the homeless. Caitlin has 3 children, which I'm currently caring for, and it has been a hardship on me because I'm trying to work full-time and care for 3 grandchildren. Instead of being the grandmother, I'm being the mother, which Caitlin should be doing. I understand that Caitlin's behavior has gotten her where she is, but Your Honor, this has been going on for 7 years with these 2 baby mama daddy drama. Okay, it's been back and forth, back and forth. I just wish that Caitlin gets herself together and stays away from the negativity. Her kids need her. They cry every day. My grandson wrote a letter to you. I don't know if you got it.
Yeah.
It was pretty sad, you know, to see him, you know, crying for his mom. And it's really hard on me. And I just ask that you find it in your heart to let my daughter come home.
Thank you.
Thank you.
And anything you'd like to tell the court before I impose sentence?
No, Your Honor.
All right. Court has reviewed extensively the information that has been provided and looked it over, and the court does believe and will follow the recommendation of the probation department. In this case, I think it's well suited to kind of deal with a number of different issues that are sort of permeating this entire case. So it's the sense of the court. I will place you on 36 months probation. That's 3 years. You are to pay $655 fines and court costs, $1,080 probation oversight fees. That will be on a payment plan as arranged by probation. There is to be no use of alcohol, recreational marijuana, or any illegal substance. You'll be subject to random testing as requested by probation. You are to complete the life skills program. You're to enroll in that within the next 60 days. You are to attend individual therapy with status reports to probation. There is to be no contact with Sarah Tessier or her children directly or indirectly. You understand that, ma'am?
Yes, Your Honor.
There is to be no use of social media whatsoever. Delete and or close all accounts on social media immediately upon your release. You understand that?
Can I ask one question? I have one page where I'm friends with my son's dad, and that's the only way I can see pictures of him and show my son. Is that okay if I just keep
pictures of
his father, who's deceased?
Yeah, I think if it's okay, Ms. Pilar and I can work something out.
Regarding that, I'm going to order that. So because I think there's been an abuse of that, and so I am going to order that her social media accounts are to be closed and deleted. All right. You are not to assault, terrorize, frighten, intimidate, threaten, harass, molest, or stalk anyone. You are not to possess any weapons, firearms, ammunition, or anything fashioned to be a weapon. You are to comply with any and all circuit court orders if there are any. You are to contact probation within 24 hours of your release from custody and then report as directed by probation. I am going to order a GPS tether through community corrections with the exclusion zone. Are you indicating exclusion zone of the entirety of Washington?
Yes, Your Honor.
All right, with the exclusion zone of Washington County. I'll schedule a review hearing on this matter for August 27, 2025 at 12 p.m. I will order 365 days in jail. Credit 17 days that you served. You're to serve an additional 14 days for the bond violations to date, and then the balance will be suspended with placement of a GPS tether as indicated prior to your release.
Yeah, I'm sorry. I should have brought this up before. Just regarding the exclusion zone, and again, this is something that Ms. Pilar and I can work out. Her doctors, like her orthopedic surgeon, is at Trinity Health in IPSI. So we can, if the court's amenable to that, and Ms. Blair, I can provide documentation regarding
I would
medical appointment.
give, correct, and for medical, that's where her medical appointments are, that will be allowed. All right, but strictly for that medical or any other necessity that she has to have within Washington County, as she would be able to report to probation.
Correct, understood. Thank you.
All right, thank you. Court does call the case People versus Christopher Minor.
Conrad Solo on behalf of Peaceville Township.
National Line, people.
Good morning, Assistant Public Defender Lawrence, hearing on behalf of Mr. Minor. Your Honor, I did attempt to make contact with Mr. Minor. I was unable to make contact.
Oh, those two separate groups there. Ma'am? All right, I'm gonna have you're with Miss Morgan, correct? You're with Mom and everybody. I'm gonna have you wait to let the others go.
Okay.
And then, okay? Thank you.
Thank you.
All right, go ahead. I'm sorry on the minor matter.
No, I apologize. I was not aware of what was happening behind me, but yeah, I attempted to make contact with Mr. Minor multiple times. I have not heard back from him. I did speak with the CMH caseworker yesterday, who indicated he did call her yesterday. So it seems like he is engaged with services, but not present.
Bench warrants will issue for defendant's failure to appear in all of these matters. Bond is set in the amount of $5,000. 10% privilege. Those warrants will issue immediately. Thank you. Court does call the case of the People versus Anton Brooks.
Conrad Solo on behalf of Pittsfield Township.
Assistant Public Defender Natalie Pate with it on behalf of Mr. Brooks, who stands to my right. Please state your name for the record, sir.
Anton Brooks. All right.
Thank you, Your Honor. There is a resolution in this matter to which Mr. Brooks will be accepting the offer from Mr. Siller of pleading to added count 2 of allowing an ineligible person to drive, and in exchange, count 1 will be dismissed. I did go over Mr. Brooks's advice of rights form with him yesterday in the jail, and he is now signing right there.
So, Your Honor, operating, allowing an ineligible person to operate MCL 257.326. Thank you.
May I have it sworn?
Raise your right hand. Do you solemnly swear in affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
Yes, sir. Yes, sir.
State your name.
Anton Brooks. Sir, it is this court's understanding you're going to plead guilty to the charge of allowing an ineligible driver to operate a motor vehicle. That is a misdemeanor punishable by up to 90 days in jail and or a $100 fine plus court costs. You understand that, sir? Yes, sir. And understanding that you still wish to plead guilty? Yes, sir. And to that charge, how do you plead? Guilty. You understand that by pleading guilty, you'll not have a trial of any kind? Yes, sir. You signed an advice of rights form, is that correct? Yes, sir. Any questions regarding any of those rights? No, sir. Please look at paragraph 5 on that form. Those are your rights which are part of a trial. You understand by pleading guilty, you'll be giving up those rights as well as all the rights on that form. You understand that, sir? Yes, sir. You understand you're giving up your right to appeal of right? I didn't say so. Yes, sir. Are you on probation or parole? Yes, sir. You are? Probation. Probation? Were you on probation at the time of this offense? Yes, sir. In April? Yes, sir. All right, I do have to advise you, then your plea could be a violation of that probation. You understand that? Sir. If it is considered a violation of your probation, that court could sentence you to the maximum allowable under that other charge or charges. You understand that? Yes, sir. Understanding that, you still wish to plead guilty to these charges? Yes, sir. Has anybody promised you anything other than what's been stated here today on the record to get you to plead? No, sir. Anybody threaten you or coerce you? No, sir. You're doing this voluntarily? Yes, sir. Of your own free will? Yes, sir. Yes? Yes, sir. And because you believe that you are indeed guilty of this offense? Yes, sir. On the date of April 6, 2025, the location of Washtenaw near Gulfside, Pittsfield Township, Washtenaw County, State of Michigan. Did you have custody or control of a motor vehicle? Yes, sir. Did you allow someone who was otherwise ineligible to operate that motor vehicle?
Yes, sir.
All right. You understand also, sir, that if I do accept your plea, and again, I'll be immediately sentencing you, so there would not be a period in time between acceptance of the plea and that, but if there were misconduct, you would not be able to withdraw your plea and any agreement with the court or any evaluation by the court. The court would no longer be bound by that. You understand that, sir?
Yes, sir.
All right. Counsel, had there been any other threats, promises, or other inducements that have led to this plea?
No, Your Honor.
Not that I'm aware of, Your Honor.
All right. Has the court complied with the court ruling? Would it be proper to accept this defendant's plea?
Yes, Your Honor.
Yes, Your Honor.
Court will accept the defendant's plea to count 2, count 1 is dismissed. Anything either of you want to say before I impose sentence?
Just briefly, Your Honor, we'll note that Mr. Brooks has, I believe as of today, 34 days of credit. So I would ask the court would consider sentencing him to a credit for time served sentence. He is being held on other matters with his next court date being the 26th of this month.
Sir, anything you want to tell me?
No, sir.
Fines and costs of $250 that will be due and payable 90 days after release. Other than 90 days in jail, credit 34, balance suspended. Thank you.
Thank you, Your Honor.
No. Court does call the case people versus Brendan Williams.
Assistant Public Defender Natalie Pate with and on behalf of Mr. Williams, who should be present via Zoom.
And that's all the people.
Mr. Williams, state your name, please.
Brendan Williams.
Thank you. 578 is annoying. Got it. All right. Before we go on to the other case, sir, you have a new case before the court that alleges that on or about April 3rd, 2025, at the location 5915 West Michigan Avenue in Pittsfield Township, that you did operate a motor vehicle with a high blood alcohol content. Do you understand the nature of that charge, sir?
Yes.
That is a misdemeanor punishable by up to 180 days incarceration, a $200 to $700 fine plus court costs. The court could order community service, any rehabilitative programs the court deems necessary. The court could also order your vehicle immobilized, could order you to pay the cost of the prosecution as well as the cost of any emergency governmental services. You understand that, sir?
Yes.
I would also indicate that there is a second offense notice so that the penalties on this would be increased to a misdemeanor punishable by up to 1 year incarceration and a fine of up to $1,000. You understand that, sir?
Yes.
First question I have for you, sir, is do you want to be represented by an attorney?
Yes.
This is a public defender case.
Assistant Public Defender Natalie Pate, again, on behalf of Mr. Williams, we waive any further formal readings, stand mute, and ask for an adjourned pretrial date in this case, Your Honor, please.
Defendant having waived formal reading, standing mute, court will enter not guilty plea. Pretrial in this matter will be adjourned to July 2nd, 2025, 9 a.m. As to bond in this case, alleged BAC.
0.294. And I will note for the record as well, Your Honor, the court noted the incident date of April of 2025. The prior conviction date is October of 2024. The arrest date for that case was August of 2024. So extremely close in time. I am requesting a scram tether.
Is there any accident?
There was not a crash. The defendant was located laying sideways in the front seat of the vehicle and was making comments about he should be in the driver's seat, things of that nature. There was not, but there was no crash.
All right. As to bond.
As to bond, Your Honor, I would request a PR bond, and we have no objection to any of this standard bond conditions. I just want to note that Mr. Williams does currently have a scram tether on him for his probation that he was sentenced to last week through 14A1. And so he does currently physically have a scram tether on him. We certainly,
Was that going to expire at some point?
I looked at the sentence and it didn't have it written on there when it would. I would speculate that it would expire at some point. Yes, I don't have that date of when that is though.
All right.
And Your Honor, if I recall correctly, I do believe that's a case that also had a drunk and disorderly charge attached to it. So alcohol does seem to be a major problem.
Both set his bond in that case at a $30,000 personal recognizance bond, all order standard conditions, including no assault behavior or possession of any weapons. There is to be no alcohol, recreational marijuana, or illegal drug use by you. I will sign a community corrections order for a scram tether, that one would be placed after expiration of the current order on the other matter. All right. What are you doing in the other case?
Your Honor, regarding the other case, I'm moving as the defense conduct does not satisfy the elements of defense.
On the disorderly person?
On the disorderly person, correct.
Any objection?
No objection, Your Honor.
That being case 0546, that case is dismissed. All right, we'll see him on the second.
Thank you, Your Honor. And thank you, Mr. Williams. You're all set for today, but we'll be in touch for the next time.
All right, thank you.
Court does call the case of the people versus Matthew Vanessa. Fonseca, I think is how it is.
Good morning, Assistant Public Defender Lauren Perny on behalf of Mr. Fonseca. Fonseca? State your name, please.
Matthew Fonseca.
Thank you.
Your Honor, we're asking for an adjournment in this case. Mr. Fonseca has a PCC before Your Honor on the 26th. I was in communication with Ms. Londy this morning as well, and I'd like to relay some things to my client about possible resolution of this case. So, and of course, the felony may drive the bus depending on what happens there. So we're just asking for an adjournment.
July 2nd, 2025.
Thank you.
Thank you.
Thanks. Have a good one.
How many are in my 11 o'clock? You can put them up there. I'll start rolling them. I mean, we can actually start calling somebody between cities.
Yeah.
Or while they're still part of the same lot. So if I got one that I can call.
Yes. So this one is ready. He's gonna call.
Court does call the case of the people versus Gabriela, is it Herrera?
Christina Bergeron for the people.
Good morning, Your Honor. Tina Saxon on behalf of Ms. Herrera, who's approaching. What's your name? Gabriela Herrera.
What are we doing?
Your Honor, today's day and time for a PCC. My client is
No, it's
willing to enter.
it's for a pretrial.
I'm sorry, pretrial felony mode again. My client's interested in entering a plea, and in discussion with the prosecutor, will be pleading as charged with HIDA.
Ida,
That's correct, Your Honor. The offer is to plead guilty to charge with HIDA.
thank you. Sever sworn.
Raise your right hand. You solemnly swear to affirm the testimony you're about to give be the truth, the whole truth, and nothing but the truth, so help you God.
Yes.
State your name.
Gabriela Herrera.
Ma'am, it is this court's understanding that you're going to be pleading guilty to the charge of embezzlement by an agent or trustee less than 200, I think it is. That is a misdemeanor punishable by up to 93 days of jail, $500 fine plus court costs. The fine could be increased to 3 times the value of the property taken. If that's greater than $500, that would become the maximum fine. You understand that?
Yes.
Understanding that you still wish to plead guilty?
Yes, sir.
And to that charge, how do you plead?
Guilty.
Now, you understand that by pleading guilty, you'll not have a trial of any kind.
Yes, sir.
You signed an advice of rights form, is that correct?
Yes.
Any question regarding any of those rights?
Yes, sir.
Please look at paragraph 5. You'll see a copy on the podium. Those are the rights which are part of a trial. You understand, by pleading guilty, you'll be giving up those rights as well as all the rights on that form.
Sure.
You understand you're giving up your right to appeal of right.
Yes.
Are you on probation or parole?
No.
Has anybody promised you anything other than what's been stated here today to get you?
No.
Anybody threaten you or coerce you?
No.
You're doing this voluntarily
Yes.
and of your own free will,
Yes.
and because you believe that you are indeed guilty of this offense? Yes.
Yes.
Between the dates of May 27, 2020, August 10, 2022, at the location of 7,000 East Michigan Avenue in Pittsfield Township, Washtenaw County, State of Michigan, were you employed at Walmart?
Yes.
All right. And what'd you do that makes you think that you're guilty of this offense?
What did you just do? I was working there and I took several items while on the job.
You took several items like what?
Without paying for them.
Okay.
Yeah.
So you took items during that period in time from the job. You did not pay for those, correct?
Yes.
You didn't have anybody's permission from Walmart to do that.
No.
That was not some benefit of your employment that
No.
you take that, build
No.
that property. This property you took, was it valued in excess of $200?
No. It was under that.
Okay. And you came into possession of this property that you took by virtue of the fact that you were employed at Walmart?
Yes.
Yes? Counsel, have I complied with the court rule? Would it be proper to accept this defendant's plea?
The people are satisfied, Your Honor.
Defense is satisfied.
Court will accept the defendant's plea of guilty to this charge. Defendant is referred, before I say that, I guess I do have to advise you of this. If you understand that if I accept your plea, ma'am, if between now and the time of your sentencing, if you commit misconduct as defined by the Michigan court rules, that any sentence agreement or any evaluation like for HIDA or other things would no longer be in play and the court is not bound by that. You understand that?
Yes.
You understand also that if you do commit that misconduct, you would also not be entitled to withdraw your plea.
Yes.
All right. And counsel, is counsel aware of any promises, threats, or other inducements that have made this plea come about other than those that may have been disclosed on the record?
No, Your Honor.
No, Your Honor.
All right. Thank you. Court will accept the defendant's plea then of guilty to this charge. Defendant is referred to probation for a pre-sentence investigation and report. Sentencing in this matter will be
July 30th at 2025 at 12 p.m.
July 30th, 2025, 12 p.m. All right.
Your Honor, I'm sorry, I'd like to add for the record that the prosecution consents to hide it in this case as the defendant was 23 years old at the time.
Got it. Okay. Thank you. All right.
Thank you.
Thank you. Court does call the case People versus Gerald Frederick. All four cases.
On behalf of student township.
Assistant Public Defender Natalie Pate with and on behalf of Mr. Frederick, who stands to my right. Please state your name for the record, sir.
Gerald Frederick. All right. What are we doing?
Thank you, Your Honor. There is a resolution in all four matters to which Mr. Frederick will be pleading no contest as charged in the case that ends in 1042. And in exchange, all other three cases will be dismissed. Sorry, Your Honor.
Go ahead. Go ahead.
I have reviewed Mr. Frederick's advice of rights with him in the jail yesterday.
He's
And he
pleading
is
no
signing.
contest in the case ending in 1042 and the others are being dismissed.
Correct, Your Honor.
Yeah. It's the one that came in. Yeah, that's all. All right, may I have him sworn?
Raise your right hand. Do you solemnly swear and affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
State your name.
Daryl Pritchard. Sir, it is this court understanding you're currently be pleading no contest to the charge of retail fraud under the Pittsfield Township ordinance. That is a misdemeanor punishable by up to 90 days, $500 fine plus court costs. You understand that?
I do, Your Honor.
Do you understand what a no contest plea is?
Yes, Your Honor.
Two things about it I have to make sure that you understand. The first thing is it means that you're not further desirous or wanting to contest this charge. You understand that?
Yes, Your Honor.
Second thing you need to understand is that for purposes of sentencing, the court will treat you the same as though you had pled guilty. You understand that?
Yes, Your Honor.
Basis for the no contest plea?
Potential civil liability.
Sir, to that charge, how do you plead?
No contest, guilty or not guilty.
No contact?
You understand that by pleading no contest, you'll not have a trial of any kind.
Yes, Your Honor.
You signed an advice of rights form, is that correct?
Yes, Your Honor.
Any question regarding any of those rights?
No, Your Honor.
Please look at paragraph 5. You'll see a copy on the podium. Those are your rights which are part of a trial. You understand by pleading guilty, you'll be giving up those rights as well as all the rights on that form.
Yes, Your Honor.
You understand you're giving up your right to appeal of right.
Yes, Your Honor.
Are you on probation or parole?
No, Your Honor.
Has anybody promised you anything other than what's been stated here today on the record to get you to plead?
No, Your Honor.
Anybody threaten you or coerce you?
No, Your Honor.
You're doing this voluntarily
Yes,
of your own free will.
that's correct.
And because, well, I won't ask you that. Counsel, the court has been provided and has reviewed Pittsfield Township Department of Public Safety report for their case number 247634. Any objection to the court having reviewed that report?
No, Your Honor.
No, Your Honor.
Sir, I do have to also advise you that if I accept your no contest plea between the time of today's date or its acceptance and the time of sentencing, if you commit misconduct as defined by the court rule, that any sentence agreement or sentence evaluation would no longer bind the court. You understand that? I wouldn't be bound by that. You understand that, sir?
I do, Your Honor.
You understand also that if you commit any misconduct, you would not be entitled to withdraw your plea.
Yes, Your Honor.
All right. Counsel, is counsel aware of any other promises, threats, or inducements which have resulted in this plea?
No, Your Honor.
No, Your Honor.
All right. And based upon a review of the police report in this case, the court does find that there's sufficient factual basis in which the court could determine the defendant's guilt of this offense. Counsel, have I complied with the court rule? Would it be proper to accept this defendant's plea?
Yes, Your Honor.
Yes, Your Honor.
All right, court will accept the defendant's plea of no contest to this charge.
Excuse me.
The case is ending in 0671, 0944, and 1267, all 2024 cases. Those matters are dismissed pursuant to the plea agreement. Defendant is referred to probation for pre-sentence investigation and report. Sentencing in this matter will be
July 7th, no,
July 9th.
July 9th, 2025 at 9 a.m.
July 9th, 2025, 9 a.m. Bond will continue. Thank you.
Thank you, Your Honor.
Court does call the case People versus Adams. Swords.
Ashley Lonnie for the people.
Good morning, Your Honor. Timothy Dinan, P49499, appearing on behalf of Mr. Sowards, who's also present on Zoom today.
Sir, please state your name.
Adam Swords.
All right. All right, what are we doing?
Your Honor, I have received some of the discovery. I'm still waiting for the police report. I've just asked for an adjournment and have this matter set for another pretrial, please.
Adjourn the matter to July 2nd, 2025, 9 a.m.
Thank you, Your Honor.
Thank you. Bond continue.
Bye-bye.
Bye-bye. Court does call the case of the People versus Justin Goltowski.
Christina Bergen for the people.
Assistant Public Defender Natalie Pate with and on behalf of Mr. Goltowski, who should be present via Zoom.
Goltowski, I don't have him.
So, Your Honor, I don't have an explanation for his failure to appear. We actually spoke yesterday and we had a scheduled appointment for Friday at 2 to further review his discovery and options. I did provide him with a Zoom link and was expecting him to be here today. I would respectfully request an adjournment for the record.
Bench warrant will issue for defendant's failure to appear, bond 5,000, 10%. That warrant will issue immediately.
Thank you, Your Honor.
Court does call the case of the people versus Stephen Grisbeck.
Conrad Solar on behalf of Physical Township.
Good morning, Assistant Public Defender Lauren Perny on behalf of Grisbeck, who is approaching. Please state your name for the record.
Stephen Grisbeck.
Your Honor, Mr. Grisbeck is going to be pleading guilty as charged. We would be asking for immediate sentencing. He has 84 days credit as of today.
He has 84 days.
Yes.
All right. I have him sworn.
Raise your right hand. Do you solemnly swear and affirm the testimony you're about to give be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
State your name.
Stephen Grisbeck.
Sir, it is this court's understanding that you are going to be pleading guilty to the charge of possession of drug paraphernalia. Is that correct?
Yes, Your Honor.
That's a misdemeanor punishable by up to 90 days in jail, $500 fine plus court costs. You understand that?
Yes, Your Honor.
All right. Still wish to plead guilty?
Yes, Your Honor.
And to that charge, how do you plead?
Guilty.
Now, you understand that by pleading guilty, you'll not have a trial of any kind.
Yes, Your Honor.
You cited advice of rights form.
May I approach? Yes.
Yes, I do.
Any question regarding any of those rights?
Oh, yeah.
Please look at paragraph 5. You'll see a copy on the podium. Those are your rights which are part of a trial. You understand by pleading guilty, you'll be giving up those rights as well as all the rights on that form.
Okay.
Yes?
Yes, Your Honor.
All right. You understand you're giving up your right to appeal of right?
Yes, Your Honor.
Are you on probation or parole?
No, Your Honor.
Has anybody promised you anything other than what's been stated here today on the record to get you to plead?
No, Your Honor.
To clarify, Mr. Grisbeck is on probation before Your Honor, but
Yes, he
this
is.
incident
yeah.
occurred before he was on probation.
Yes. Anybody threaten you or coerce you?
No, Your Honor.
You're doing this voluntarily
Yes, Your Honor.
of your own free will
Yes, Your Honor.
and because you believe that you are indeed guilty of this offense?
Yes, Your Honor.
All right. I do have to advise you, although I'm likely to impose immediate sentence, that if you commit misconduct between the time of this plea and the time of my sentence, that you would not, first of all, be allowed to withdraw your plea, and that any potential sentence agreement and or evaluation would no longer bind the court. You understand that?
Yes, Your Honor.
All right. So, sir, on the date of September 3rd, 2024, at the location of Packard Road in Pittsfield Township, Washtenaw County, State of Michigan, did you have drug paraphernalia in your possession?
Yes, Your Honor.
What'd you have?
A syringe.
All right. And you use that for the taking of drugs?
Yes, Your Honor.
All right. Counsel, have there been any other promises, threats, or inducements that you're aware of that have led to this plea?
No, Your Honor.
No, Your Honor.
All right. Has the court complied with the court rule? Would it be proper to accept this defendant's plea?
Yes.
Yes, Your Honor.
Court will accept the defendant's plea of guilty to this charge. Sir, anything you want to say before I impose sentence?
Not this time, Your Honor.
Anything, Ms. Perny?
No, Your Honor, as I stated, we would ask for credit for time served. He has 84 days of credit in the Washtenaw County Jail. And when he's released from here, he will be on probation before Your Honor in Ms. Pilara.
This is last case before me.
I think so, yep.
Been showing up forever.
I'll see you again on July 7th.
So no.
He's back.
He's back.
Just
All
for
right.
probation review, though. It's
Okay. but-
not a nude case, so.
All right. Sentence of the court. State minimums of $125. I will then sentence him to 84 days, Washtenaw County Jail, credit 84, sir. All right.
All right, thank you.
You're up.
Thank you.
Court calls case of the people versus Lamar Hampton.
Ashley for the people.
Good morning, Assistant Public Defender Lauren Perny on behalf of Mr. Hampton.
Mr. Hampton,
Lamar
can you state
Hampton.
your name, please? Thank you.
Lamar Hampton.
Your Honor, I am requesting an adjournment of the pretrial hearing, and Mr. Hampton will get over some documentation regarding his efforts towards getting his license, and I would like to have another conversation with the people.
July 2nd, 2025, 9 a.m. Thank you, Mr. Hampton. Court does call the case of the people versus Roman Hop.
Christina Bergeron for the people.
Good morning, Assistant Public Defender Lauren Perny on behalf of Mr. Hop. Please state your name.
Vermont Hop.
Who will make sure that he has full pants on when he comes here again.
We'll have a conversation about pants, Your Honor.
All right, what are we doing?
We're asking you to set this for final settlement, please.
Jury final settlement conference will be August 8th, 2025 at 9 a.m. Jury selection, if necessary, August 11th, 2025 at 8:30. Both of those proceedings are in.
Thank you.
Court does call the case people versus Otis Elliott.
Christina Bergeron for the people.
Good morning, Assistant Public Defender Lauren Perny on behalf of Mr. Elliott. And sure, I did attempt to contact Elliott. I didn't hear back from him. I'm not sure. He was being present in the courtroom. I'm not sure if he's on Zoom.
He is not.
I do not have an explanation for his failure to appear. For the record, I request an adjournment of this pretrial.
Bench warrant will issue for defendant's failure to appear. Bond will be set in the amount of $5,000. I'll give a 10% privilege. That warrant will issue immediately. Who? They're coming in right now. Court calls case people versus Ariana Jenkins.
Conrad Silver on behalf of Pittsfield Township.
Assistant Public Defender Natalie Pate with and on behalf of Ms. Jenkins, who stands to my right. Please state your name for the record, ma'am.
Ariana Jenkins.
Thank you, Your Honor. Today, we're here for both a bond violation and a pretrial. As to the pretrial, well, I'm happy to address whatever, Your Honor.
Go ahead.
So as to the pretrial, I'm just requesting a very brief adjournment. The people have extended an offer of this case for my client to plead to an added count 2 of operating while intoxicated. I was able to briefly discuss that with her. However, we need more time to discuss both the ramifications of that potential resolution. So I would be asking for a very brief adjournment. And I am also prepared to address the bond violation when appropriate.
Turn it to July 2nd, 2025. As to the bond violation.
Thank you, Your Honor. As to the alleged bond violation, which is that Ms. Jenkins did not report to community corrections to obtain her SoberLink device, I have discussed that with her and she does admit to that bond violation. She did turn herself in yesterday at 2142 to the Washtenaw County Jail on this warrant on my advice to do so. We are asking that the court would release her today. She does understand that if she were to be released, she would have to, it is likely that a community corrections re-referral will be ordered and that it is likely that that may be a scram tether at this time. She does understand that she would likely be fitted with that before her release from the jail. I am asking that the court release her. She does have strong ties to this community. She does live in Saline with her mother, her cousin, and her grandma. She has full-time plus employment, working 6 days a week at a senior residential living / nursing home. In speaking to my client and upon what I can access, it is my understanding she has no prior criminal convictions and no other pending matters. She has strong family support. Frankly, I asked her when I received this bond violation and was in contact with her, I asked her why she did not go to pick up the SoberLink. She did state to me that she went to the court clowner, was told that it might take a couple hours for the SoberLink to be ready after the order was provided. And she was in fear of losing her job if she didn't show up in time to her shift. So she left and went to work. I did advise her that candidly, she should not have done that. She should have waited and complied with this court's orders. My client does understand that, and she does understand that this is a very, very serious matter. After the bond violation was issued, she was in both contact with me and then on her own did submit a bench warrant recall.
Since this, we've had many conversations. She did turn herself in on the warrant yesterday. She takes these court orders seriously. She just wants to apologize to the court and ask for another chance. It is my understanding that there is no drinking events and that there are no other alleged
I ran
violations.
her a personal recognizance bond with a teller prior to release.
Thank you, Your Honor.
Thank you.
Thank
July
you.
2nd.
Thank you, Your Honor.
Yes, so get her on it. Court does call the case People versus Jessica Fox.
Good morning, Assistant Public Defender Lauren Perry on behalf of Ms. Fox.
Ms. Fox, can you state your name, please?
Jessica Fox.
Your Honor, we're requesting an adjournment. Lonnie and I did have a conversation this morning about this case. I just want you a little time to speak to my client.
July 2nd, 2025, 9 a.m.
I'm gonna call you, Ms. Fox. Thank you, Your Honor.
All right, thank you.
Court calls the case People versus Marcus Moore Jones.
I didn't get this information, that's why I'm here.
What?
I didn't get this information, that's why I'm here.
What's your name? Okay, you can be here. Come on up. Is that because you were wearing shorts? You didn't want to come up?
No, I kind of woke up late today. I thought I was gonna miss court. Not gonna lie, Judge Simpson. I woke up and came straight here.
And had no pants?
Nope, this is exactly what I had on. Except for the shoes, but.
No, we won't let that happen next time, right?
Yes, sir.
All right. Mr. Moore Jones, you are before the court on a misdemeanor citation that alleges that you did operate a motor vehicle without proper security or insurance that is alleged to have occurred April 29, 2025, US 23 in Pittsfield Township. You understand the nature of that charge, sir?
Yes, sir.
That's a misdemeanor punishable by up to 90 days, a minimum of $200 and up to a $500 fine plus court costs. You understand that?
Yes, sir.
First question I have for you is, do you want to be represented by an attorney?
Yes, sir.
It's a public defender case.
Assistant Public Defender Natalie Pate with and on behalf of Mr. Moore Jones, we would waive any further reading, stand mute, and ask for an adjourned pretrial date.
Pretrial in this matter will be adjourned to July 2nd, 2025, 9 a.m. You think you can make that time?
Yes, Your Honor.
You ain't going oversleep?
No.
You sure?
No. I'm not going oversleep.
All right. Well, if we do, I got your address. We'll come get you.
All right. I know that for sure.
Stand in every way for a reading, standing mute, equivalent or not guilty plea. July 2nd, 2025, 9 a.m. Set his bond at a $5,000 personal recognizance bond. I'll order standard conditions, including no assaultive behavior or possession of any weapons. I will also order that there's to be no use of alcohol, recreational marijuana, or any illegal.
Thank you, Your Honor.
Thank you.
Thank you.
Thank you.
Oh, sorry.
No.
Court does call the case of People versus Chad Jones.
Conrad Soder on behalf of Pittsfield Township.
People.
I have 3 cases.
Sorry. Good morning, Assistant Public Defender Lauren Perry on behalf of Mr. Jones. Mr. Jones, please state your name for the record.
Chad Jones.
As Your Honor knows, Mr. Jones has felonies before Your Honor at the PCC stage. Everyone's working to get him into treatment, so we're requesting an adjournment for that and also work something out.
So his felony cases, we adjourned to what day?
July 3rd.
July
3rd.
3rd. Okay. Well, dear, doesn't do any good to put these on the 2nd then.
Probably not.
So I'll adjourn these all then to July 16th, 2025 at 9 a.m. And if we get a resolution, have to do something, we'll try to deal with these early. Yeah. All right.
Thank you.
Thank you, Mr. Jones. Bond continue. Let's call the case of the People versus Pauline Marcharia.
Assistant Public Defender Natalie Pate with and on behalf of Macharia, who is present via Zoom. Ma'am, can you please state your name for the record?
Pauline Macharia.
All right. What are we doing?
I have discussed this matter with Ms. Londi. It was my understanding that this case was going to be dismissed.
Crickets.
Sorry, Your Honor, I'm so sorry. My notes are on a slow bus from Detroit. It's
Whoa.
a long time.
Wow.
Thank you, Alan. Yes, this case will be dismissed. Thank you.
All right.
Get the paperwork over.
Case is dismissed without objection.
Yes,
All
there's
right.
no objection.
Thank you, ma'am.
Thank you.
Thank you, ma'am. You're all set.
All right, thank you, ma'am.
Court calls the case People versus Todd Reberg.
Conrad Siller on behalf of Pittsfield Township.
Good morning, Assistant Public Defender Lauren Perny on behalf of Mr. Reber. Mr. Reber, please state your name for the record.
Todd Brian Rayberg.
Your Honor, we are requesting an adjournment of the pretrial. I do have an order for the court to consider releasing him to treatment. He was before Your Honor yesterday, and
Yes.
I believe Your Honor signed that.
When did we adjourn your case yesterday to?
Third.
Okay.
Order courtesy of Ms. Yagi.
Pardon?
The order's courtesy of Ms. Yagi.
I know that. I'm glad you finally have talked to her and listened to her.
I know, it's
Trying to get the others to do the same.
a pretty nice order.
It's a beautiful order.
So that's our
Done
only.
correctly. Not something I expected from your office. Go ahead.
Hang, catch and
Wow, that was a shot.
That wasn't even a straight. That was a direct hit. So that's our only request here. Well, I guess both requests an adjournment and the order to be released.
All right. And again, you're looking at some type of global resolution ultimately.
Right. This is a possession of drug paraphernalia case. So the standing offer from Mr. Sillish dismissed if treatment's completed, and he has felonies, multiple felonies or one felony?
And Your Honor, he does have 2 drug paraphernalia cases in this court. That's why his case is 0195.
Oh, that's correct. It is set on July 2nd.
The other case.
Yeah.
Okay. Then, well, why don't I just put this on July 2nd, understanding we might have to adjourn it, but then everything will be together.
Yeah.
And he may get out on this.
Yeah. Thank you, Your Honor.
All right. Thank you. Thank you, Mr. Wood.
Thank you.
Court does call the case People versus Chad Maurer.
Epsilon for the people.
Good morning, Assistant Public Defender Lauren Perny on behalf of Mr. Maurer. I'm not sure if he's on Zoom.
Chad Maurer. He's there, but he's not.
Hey, there we are.
State your name, sir.
Chad Maurer.
Okay.
Your Honor, I'm requesting an adjournment. Mr. Maurer and I did not have a chance to connect prior to today's hearing. His mom did inform me, though, he started a new job, and that's likely why he's been working a lot, and that's likely why we have missed each other. So I just like a chance to speak to him about resolving this file.
July 2nd, 2025, 9 a.m.
Thank you, Your Honor.
All right. Thank you. Thank you, Mr. Maurer.
Yep.
Court does call the case of the People versus, is it Aneja O'Hearn?
Epsilon for the people.
This arraignment. Court will issue an order to show cause for their failure to appear. Court does call the case of the People versus Brandon Smith.
Conrad Silver on behalf of the Sioux Township.
This is an arraignment.
Yes, I'm sorry.
You know what, Your Honor, I'll make it easy. I'm going to dismiss. Defendant's conduct does not satisfy the elements.
Sir, you have any objection to that?
I do not, Your Honor.
I didn't think. All right, case dismissed.
Thank you,
Take
Your
care of yourself.
Thanks, sir.
Court calls case People versus Rebecca Miller.
Pass the line to the people.
Assistant Public Defender Natalie Pate with and on behalf of Ms. Miller, who appears via Zoom. Ma'am, can you please state your name for the record?
Rebecca Miller.
Thank you, Your Honor. So fortunately, Ms. Miller is back at Dawn Farm, no longer at the hospital. So today we can do the resolution that we intended to do at the last pretrial before Ms. Miller was unfortunately had emergency surgery. I do have a plea form here, and Your Honor should be in receipt of the police report as well as signed advice of rights form that I submitted prior to the last pretrial.
I don't know that I still have the police report in the file.
Here, the offer that was produced writing in front of you is to plead to that add count 2 of retail fraud in the 3rd degree, dismiss count 1 retail fraud in the 2nd degree.
All right. We have a report.
I'm sorry, I should have submitted it again probably or twice. I didn't.
All right.
I didn't know if it was kept.
Ms. Miller, we'll come right back to you. Let me pass this matter briefly. I'm sure I reviewed the report. I just don't have it in front of me. Okay. Court to pass that case. Court does call the case People versus Leo Stringa.
The people.
Assistant Public Defender Natalie Pate with and on behalf of Mr. Stringa, who is approaching.
Your name, sir?
Leo Stringa.
All right, what are we doing?
Thank you, Your Honor. This is a first pretrial in this case. I'm respectfully requesting an adjournment to, well, first of all, fully discuss this with my client as well as in tandem with his other matters. He's scheduled for his next court date on July 3rd. I believe it's a probable cause conference on his new felony retail fraud case. I would request an adjournment possibly till after that date, if Your Honor would allow.
July 16, 2025, 9 a.m. Bond continued.
Thank you, Your Honor.
Thank you, Your Honor.
Court does call the case People versus Kenneth Miller.
Echelon for the people.
He is into.
Kenneth Miller.
Kenneth Miller.
Sir, you are before the court on a misdemeanor complaint that alleges that on or about March 19, 2025, at the location of 7000 East Michigan Avenue, Pittsfield Township, Washington County, State of Michigan, you did operate a motor vehicle while intoxicated with an occupant less than 16 in that vehicle. Do you understand the nature of that charge, sir?
Yes, Your Honor.
That is a misdemeanor punishable by a fine between $200 to $1,000, not more than 1 year in jail. The court could order community service as well as any rehabilitative services the court deems necessary. The court could also order your vehicle immobilized, could order you to pay the cost of the prosecution as well as the cost of any emergency governmental services. You understand that, sir?
Yes, Your Honor.
All right, first question I have for you is, do you want to be represented by an attorney?
Yes, please.
It's a public defender case.
Good afternoon, Assistant Public Defender Lauren Kearney on behalf of Mr. Miller. We'd waive formal reading and stand mute to the charges.
Defendant having waived formal reading, standing mute, court will enter a not guilty plea to these charges. You're asking for an adjournment?
Yes, Your Honor.
I will adjourn this to July 2nd, 2025, 9 a.m. As to bond.
Your Honor, in this case, the defendant, as charged, did have a person under 16 in the vehicle. I do believe that was his 6-year-old child. There was a crash, and his alleged VAC is .210. I am requesting a scram tether.
Your Honor, and as for a personal bond, I think a scram tether is reasonable request.
Bond in this case will be set in the amount of $20,000 personal recognizance under standard conditions, including no assaultive behavior or possession of any weapons. There is to be no use of any alcohol, recreational marijuana, or any illegal drug. You understand all of that, sir?
Yes, Your Honor. I have one question about is the scram tether, is that an alcohol tether or a GPS tether?
That's well, it has GPS capabilities, but it is an alcohol tether.
Okay.
I'm going to order that you report over to the Department of Community Corrections for placement on a scram tether. You need to do that within the next 24 hours, sir.
Yes, Your Honor.
All right, thank you.
Thank you.
Next date was 7/2, Your Honor.
Yes.
Thank you.
Court does call the case People versus Shania Williams.
Conrad Silver on behalf of Caseyville Township.
Afternoon. This is the public defender Lauren Perry on behalf of Ms. Williams. Okay, please. Your Honor, I did attempt to make contact
Did
with.
your computer get on the same bus as Miss Lonnie?
Yeah, it was, and maybe my brain as well. Hi, good morning. I didn't have contact with Miss Williams. I did not realize you were in custody, so I apologize. This is a license case. Are you being held on other cases, I presume?
Yes, ma'am.
Okay, so I would just ask for an adjournment of this case.
July 2nd, 2025, 9 a.m.
Thank you.
And I don't know if you stated your name for the record. Can you state your name, ma'am?
Shania Williams.
Thank you. All right. Thank you. Yeah,
And the problem, okay, yeah, I'll come. and we'll
I did not
Okay.
start anything on this. Court recalls the case People versus Miller.
Rebecca, Your Honor.
Yes, Rebecca.
That's
Miller.
the one for people.
Assistant Public Defender Natalie Pate with and on behalf of Ms. Miller. Ma'am, could you please state your name for the record?
Rebecca Miller.
Court's understand she's going to plead no contest to the charge of retail fraud in the third degree. Upon a successful no contest plea to that charge, count one would be dismissed. That's the court's full understanding of the.
Correct. Yes, Your Honor. And that is my understanding as well as my clients that we have discussed, and she would like to accept that offer, pleading no contest today.
Ma'am, can you please raise your right hand?
Sorry.
You solemnly swear or affirm testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God.
Yes, Your Honor.
All right. State your name again for the record, please, ma'am.
Rebecca Miller.
All right. Ma'am, it is this court's understanding that you are going to be pleading no contest to the charge of retail fraud in the third degree. That is a misdemeanor punishable by up to 93 days in jail, $500 fine plus court costs. The fine could be increased to 3 times the value of the property taken. If that's greater than $500, that would become the maximum fine. You understand that?
Yes, sir.
All right. Do you understand what a no contest plea is?
Yes, sir.
All right. 2 things about it I have to make sure you understand. It first of all means that you're not further desirous or wanting to contest this charge. You understand that?
Correct, Your Honor.
The second thing you need to understand is that for purposes of sentencing, the court will treat you the same as though you had pled guilty. You understand that?
Yes, Your Honor.
All right. Basis for the no contest plea.
Potential civil liability, Your Honor.
All right. So, ma'am, to that charge, how do you plead?
No contest.
Now, you understand that by pleading no contest, you'll not have a trial of any kind.
Correct.
You had previously signed an advice of rights form, is that correct?
Yes, Your Honor.
All right. Do you have any questions regarding any of those rights?
No.
You understand that you're giving up all of those rights, including those contained in paragraph 5 on that form, which are your trial rights. You understand that?
I do.
You understand you're giving up your right to appeal of right.
Yes.
Are you on probation or parole?
I am not.
Has anybody promised you anything other than what's been stated here today on the record to get you to plead?
No, sir.
Has anybody threatened you or coerced you in any way?
They have not.
You're doing this voluntarily and of your own free will?
I am, Your Honor.
All right. The court had previously been provided and has again been provided Pittsfield Township Department of Public Safety report for their case number 24-14501. Any objection to the court having reviewed that report?
No, Your Honor.
No, Your Honor.
All right. Ma'am, I do have to advise you that if I accept your plea, if you commit a misconduct between the time of this plea and sentencing, that any sentence evaluation or any agreement regarding sentencing, the court would not be bound by. You understand that?
Absolutely.
All right. I also have to advise you that if you do that, you are also not entitled to withdraw your plea. You understand that, ma'am?
I do, Your Honor.
All right. Based upon a review of that report, the court does find that there's a sufficient factual basis in which the court could determine the defendant's guilt to the defense counsel. Have I complied with the court rule? Would it be proper to accept this defendant's plea?
People are satisfied.
Yes, Your Honor.
Court will accept the defendant's plea to count 2. Count 1 is dismissed, I should say, and I need to ask counsel, were there any other promises, threats, or other inducements which led to this plea?
Not that I'm aware of, Your Honor.
None that I know of, Your Honor.
All right. Court will accept the defendant's plea to this charge. Defendant is referred to probation for a pre-sentence investigation and report. Sentencing in this matter will be
July 30th, 2025, at 12.
July 30th, 2025, 12 noon. Okay. And are they on? Yes, they are. All right, Ms. Miller, I'll ask you to, bond will continue. I'll ask you to wait on the line. We're going to put you into a breakout room with our probation department to start that intake process, okay?
All right, thank you, Your Honor.
Thank you.
Thank you, Your Honor. Thank you, Ms. Miller.
Court does call the case People versus Rick Artuso. 3 cases.
Good afternoon, Your Honor. May it please Honorable Court, Judge Simpson, Rick Artuso.
Assistant Public Defender Natalie Pate with and on behalf of Mr. Rick Artuso in the cases ending in 1657 and 1656. State your name for the record, sir.
Rick Artuso. Thank you. What are we doing?
Your Honor, there are felony matters that are pending at circuit court, which we're looking toward resolution of the case. I'm just suggest we adjourn this matter pending resolution of those cases.
And I did discuss Mr. Artuso's options with him. He stated to me he did not want to adjourn at this time these 2 cases. However, there are no current offers. I would be requesting an adjournment to join to follow Mr. Burgess' case.
You've got other cases up there?
Yes,
sir.
Your Honor. Sorry.
Oh, right. Yes. In circuit court? Yeah. Okay, you understand the reason they're asking for the adjournment? I understand you don't want it, but you're not going to be going anywhere and they're trying to get all of your stuff resolved. Oh, okay. You follow that? Yeah. Okay. It makes sense to do that. Do we know when your other cases are set up in circuit? The 2nd.
Yeah, pre-trials on second. Yeah.
July 2nd. Okay. So that would be the same date I'd adjourn these, but those are going to be at 1:30. I'd be hearing them before then. So here's what I'm going to do, sir. And if we got to figure out scheduling wise how to do something different, I'm going to adjourn these to July 16th, 2025 at 9 a.m. And if we have to figure out something before then, we'll do that so that you can be heard doing that. Okay? Okay. All right. Thank you.
Thank you, Your Honor.
Yeah.
I have not yet had one that is signed.
Okay. They are out of custody.
They're out. Oh, and now that I say that. I'll let you know what she says. Oh, here she is. She's doing it now.
Good afternoon, Melanie. You're in front of the Honorable J. Cedric Simpson of the 14th District Court of Washtenaw County, State of Michigan. We need your assistance with one matter this morning. Our number is 142.
I need you to hold on.
Okay, go ahead with that number.
1423.
1423. Okay, got that. One moment. Okay, and my name is Melanie with Language Line Solutions. I'll be your sign language interpreter, and your call may be monitored for training and quality assurance. And let's see. Who is the person I'm interpreting for?
We will.
Since we're on Zoom, it just keeps jumping back and forth between all the screens. So I just need to pin whatever screen we're on.
Yes, we're going to lock the podium. And
Okay.
would call the case of the people versus Orlania de la. Is that right? Not sure how they're doing. I know.
Christina Baragarian for the people.
Hold on. May I first of all have the interpreter sworn? Oh,
Can you raise your right hand, ma'am? Do you solemnly swear or affirm that you will interpret accurately, completely, and impartially, using your best skill and judgment, and to translate from English into American Sign Language, and from American Sign Language into spoken English, in a manner not before the court, so help you God?
Yes.
counsel, state your appearances.
Christina Baragarian for the people.
Dan Garin on behalf of Miss De La Rosa.
And ma'am, if you could state your name.
And this is the interpreter speaking. Again, I'm not sure which person I'm interpreting for because it keeps jumping around on all of the screens. So I'm seeing like 5 different people.
Okay. We don't have it locked, I don't.
I have it locked on the podium, but the interpreter would need to pin.
All right. Madam Interpreter, I'm informed you would need to pin the courtroom.
Okay.
We have it locked on the podium.
Let me see. So is it the one that says 14A District Court? Or
What is our
screen name that I'm going to be pinning?
14A1 District Court? Yes, ma'am.
Okay, I do have that pinned, but for some reason it's still jumping. Like right now I have whoever is at home with the glasses on.
Got it.
And their hair pulled back.
Okay.
Even though I don't have them pinned. They're the one so I can't
actually,
the District Court
the one that, do you see one that says 14A District Court bench?
Yeah.
Is she in speaker?
Just a second. Do you see that one, ma'am?
Are you asking the interpreter?
Yes.
Yes,
I'm asking you. That's the one that I think needs to be pinned.
I do have it pinned, but for some reason it is not the one showing up. I have it pinned, and when I go up, if I remove, it says I can remove. Let me try doing something else here. Hold on.
All right.
I'm closing. I had something on my screen saying something about breakout rooms, so I'm closing that out. Okay, it looks like I might be okay now. Let's give it another try. Let's go ahead.
Okay.
I was just apologizing to her. We're going to go ahead and try again.
All right. Could you ask her to state her name, please?
Orlina Madeira De La Rosa.
Thank you. what are we doing on this case today?
We will waive reading.
I'm here for the retail. Go ahead.
We will waive reading of the complaint and stand mute. But there is a resolution for pretrial, Your Honor.
And what is that resolution?
My client will be pleading guilty to retail fraud second degree. But under the prosecutor's deferred sentence program, and she has signed an advice of rights.
Ma'am, if you could please raise your right hand to be sworn. Do you solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Interpreter. All sides. One moment, Madam Interpreter and Ms. De La Rosa. We're trying to get the interpreter pinned on our large screen a little bit larger for you.
Okay.
Won't we tell those two they need to shut off their monitors? We've got that. Make it a little bit easier here. De La Rosa, it's a court's understanding that you are going to be pleading to the charge of retail fraud, second degree.
Yes, I understand.
That is a misdemeanor punishable by up to 1 year in jail. A $2,000 fine plus court cost. The fine could be increased if 3 times the value of the property taken. If that's greater than 2,000, that value would become the maximum fine. Do you understand that, ma'am?
I understand.
To that charge, how do you plead? Guilty or not guilty?
I don't know. I've never experienced this before. I guess I want to try to do probation.
Ma'am, the judge is asking if you plead guilty so that you can proceed to probation like your husband.
Oh, yes, yes, guilty.
Okay. So that we're clear, you are pleading guilty to this charge, ma'am?
Yes, guilty.
You understand that by pleading guilty, you will not have a trial of any kind.
I understand.
You signed an advice of rights form today, is that correct?
Yes, I did today.
Do you have any questions regarding any of the rights on that form?
I just want to know about how long I will be on probation.
I cannot answer that, ma'am. As to the rights that are on the advice of rights form, do you have any questions?
No. No.
Please look at paragraph 5 on the podium. Those are your rights which are part of a trial. You understand you're giving up those rights as well as all the rights on that form.
I understand.
You understand that you're giving up your right of appeal of right.
Yes, I understand.
Are you on probation?
No.
Are you on parole?
No.
Has anybody promised you anything other than what's been stated here today to get you to plead to this charge?
No.
Has anybody threatened you or coerced you in any way to get you to plead?
No.
You're doing this voluntarily and of your own free will?
Yes, I think so, yes.
And also because you believe that you're guilty of this offense?
Yes. Yes, I did. Yes.
I do have to advise you that if you commit misconduct between the time of this plea and the time that you're sentenced, you would not be able to withdraw your plea.
I understand.
And also, there would then be no guarantee that you would receive the prosecutor's deferred sentence.
Okay.
Ma'am, on November 20th, 2024, at the location of 7,000 East Michigan Avenue in Pittsfield Township, that being the Walmart store. Did you come to the register to purchase items?
Yes.
There are items that you were going to purchase that you skip scanned or did not run through the scanner.
Correct.
And you knew that the items were not being scanned.
Some I paid for, some I didn't. Yes.
The amount of the items that you did not pay for, that was in excess of $200.
Yes.
The store was open to the public at the time.
Yes, it was open.
You did not have anybody's permission to take that property, did you?
No.
And the property that you took was property that Walmart had offered for sale?
What do you mean?
The
Say that again.
The property that you took was property that Walmart was selling.
Oh, yes.
Counsel, are you aware of any other promises, threats, or any promises, threats, or other inducements that have led to this plea?
No, Your Honor.
And no, Your Honor.
Counsel, have I complied with the court rule? Would it be proper to accept this defendant's plea?
Yes, Your Honor.
Yes, Your Honor.
Court will accept defendant's plea of guilty to this charge. Defendant is referred to probation for a pre-sentence investigation. Sentencing in this matter will be
July 30th, 2025 at 12 noon.
July 30th, 2025, 12 noon.
Okay.
Your Honor, I have a travel request.
She needs to go to New York.
Yes, Your Honor.
Is she going on July 3rd?
Exactly correct.
Yes, Your Honor.
When will she be returning as opposed to the other defendant?
July 29th.
Okay. Defendant may travel to New York July 3rd through July 29th.
Thank you, Your Honor.
I will set the defendant's bond at a $5,000 personal recognizance bond. I will order standard conditions, including no assaultive behavior or possession of weapons. There is at this time to be no use of alcohol, recreational marijuana, or any illegal drug. And she is not to enter any Walmart in the state of Michigan. Thank you.
Thank you, Your Honor.
All right, thank you. Madam Interpreter, thank you. Wonderful job. Do appreciate it.
Sorry about everything setting up at the beginning, but I'm glad it smoothed out. Thank you so much for using our services. Have a nice day.
Take care.
Bye.
Okay. All right. Court. Okay, well, I know what's going to happen this time. Court does call the case, People versus John Farrow.
You're ready to start counsel, Your Honor.
Well, issue an order to show cause. I think it will matter. Court does call the case, People versus Armani Denario. Scenario,
Actually, read.
pardon? Oh, it is Reed.
Actually, want to.
Why did they do?
By June 25th, okay?
Thank you, Judge. Have a good day.
You too. Thanks a lot. Joseph William Mackey.
Ready, Your Honor.
25B148373.
Good morning, Judge. Joe Cross on behalf of Joseph Mackey, and I have T55824.
Sir, your name?
Joseph William Mackey, Your Honor.
All right, so your client pled guilty to the charge of operating while visibly impaired. There were agreed upon cost of recovery of $150.
Yes, sir.
Have you had a chance to review the screening and assessment report with him, and are there any material additions, corrections, or deletions?
I did, and no, there are not.
Okay, anything you would like to say on his behalf?
Judge, I'm not into sob stories for an OWI. I got to address this situation. I happen to have buried a family member at age 62 last Friday from a brain tumor. His wife had battled breast cancer for 3 years. It's been an awful 3 years. They bowled every other Saturday night. This was a bowling night that was involved. His wife was too ill to go. He went out, his 50th birthday was coming up, people buying him drinks, whatever. Goes out after, which he never does. She passed away a short time later. His guilt is overwhelming. He rides his bike to her gravesite every day because it's not included in his restricted license privileges. I really believe this was an anomaly. The only reason I'm asking and informing the court of this is because I know there's substance abuse treatment recommended. I would ask the court to consider, let's see how he does. He's not had a drop. He doesn't plan to have a drop. He knows what he did was wrong. His guilt is overwhelming. If he slips up at all, I would be all for whatever the court needs to do to fix that, but he's going to abide by this court's order. Oh, thank you.
All right. Just give me 1 second. Sir, anything you'd like to say? I'm sorry about your wife.
Thank you, Your Honor. I think Joe summed it up quite well. I'm just thankful that nobody got hurt that night, and I'm very sorry for what I did.
Can I trust you're not going to do this again?
That's never gonna happen again.
Anything else?
No, Your Honor.
6 months probation. You cannot leave the state without the consent of the court or violate any law or ordinance. You change your address, your place of employment, or home telephone number, you must notify probation. You have to report as directed. No alcohol, no marijuana, no illegal drugs. You're not to purchase, possess, or consume any one of those. Kratom, poppy seeds, and CBD oils are prohibited. Consuming food or other items containing those substances will be deemed a violation. You're to submit to chemical testing, PBTs and ETGs. I'm going to make it monthly for 4 months and then on demand if you're clean. I'm not going to order the treatment program. I am going to order an alcohol education program, 4-hour program through PERS. And the victim's impact panel. Everybody should sit through that, frankly. I'm going to also order, I forgot to turn on my video. There we go. I'm going to order fines in the amount of $300, costs in the amount of $300, $75 victim's rights fee, $50 justice assessment. I'm sorry, $400 in costs. So you have $825 in fines and costs. Screening fees $60 for $885. Probation fees are $120 for $1,005.
You can pay today, Your Honor.
And then you also have cost of recovery of $150 for $1155. If you violate, your probation could be revoked. You could be incarcerated for 93 days. Again, 2 days jail credit, 1 served 1, and I'm going to let you do that with community service 1 day, and I want you to complete that by August the 1st. You may be eligible for early discharge if you're compliant. So in 3 months, if you want, if you've got everything done, and there's been no violations, you can apply for early discharge and it will be granted. You have 21 days to appeal, 14 days to apply for a court-appointed lawyer for purposes of appeal if you cannot afford one. Do you understand that?
I do, Your Honor.
All right, he's got a clean record. I'm comfortable with this. You can pay that today?
I can.
And then you go over to probation and meet with them. I wish you well. Again, I'm sorry. I'm sorry for you too, Mr. Cross.
I appreciate that, Your Honor. Always good to see you.
You too. Have a good day. Good luck. Daniel Russell Sapp, 25I-414-895. Could I have seated up here, please, Juan Ortiz at the table, my right, your left? Podium, sir. Your name? You're charged with driving on a suspended license, and you have the right to a lawyer. If you want a lawyer for arraignment, I'll give you one. If you tell me, Judge, I don't want a lawyer, I will arraign you, I will enter a not guilty plea, and I will send you to the Groseal Township prosecutor. Do you understand that?
Yes, I do.
Okay. Do you want a lawyer?
I don't know if I'm speaking out loud here, but I did advised by the police officer on site.
I don't want to know what the police officer told you.
Well, then I would like one, yes, please.
Okay, you go ahead and you go talk to the defense lawyer. He'll set you up and then you'll come back in front of me, okay?
Perfect, thank you.
All right. People against Juan Alexander Ortiz. Come on up to the podium, please. 25B148-377. Could I have Justin Schroeder seated at the table? Your name, sir?
Juan Ortiz.
Good morning. You're charged with telephone harassment. You have the right to a lawyer. Do you want a lawyer? I'm sorry? Do you want a lawyer? You waive your right to a lawyer? Yes? You have to keep your voice up.
Yes, sir.
Okay. I'm going to go ahead and arraign you, and then we'll go from there. You're charged with telephone harassment. This allegedly occurred on February the 18th of 25 at or near 19341 Allen Road in the township of Brownstown. Telephone harassment under local ordinance is punishable by up to $500 in fines, 90 days jail costs, or all of those penalties. Do you understand that?
Yes, sir.
Did you sign the advice of rights and read and understand the rights?
Yes.
If you plead guilty, you will be giving up all those rights and there will not be a hearing or a trial. Do you understand that?
Yes.
All right. Again, you have the right to a lawyer. Do you want a lawyer?
Well, it was big communication. I was hospitalized for 3 days. And
Okay, so wait.
I really don't know what I'm doing here.
I don't know what you're doing here either,
Me neither.
but somebody charged you. They think you did something wrong. I'm
Yes,
not.
it was big
Wait.
communication.
Somebody thinks you committed the offense of telephone harassment. I'm not. You might be the most oppressed person in the history of the American judicial system. I'm not saying you're not, but I don't want to talk about it. We should not be having this conversation. Okay? You can advance your interest if you want with the prosecutor on your own, or I can give you a lawyer. Either way, I'm entering a not guilty plea for you right now. I'm going to set a bond. I'm going to give you a personal bond. You showed up here voluntarily. I have no problem with that. And I don't mean to cut you off. I just don't want you to talk about the case and say anything against your interest. $1,000 personal bond. You cannot leave the state without the consent of the court. You cannot violate any law or ordinance. You must appear in court as directed. No contact with Jacqueline Elayan, Elayyan. No contact with prosecution witnesses except through your lawyer. You cannot possess firearms. You cannot possess dangerous weapons. Do you understand that?
Yes.
So just so you know, I'm going to tell you a little bit here. It says defendant contacted Brownstown Forest View, located at 19341 Allen Road in Brownstown, and spoke to Jacqueline Elayan. During these phone calls, defendant threatened to come into the business and, quote, shoot up the place, end quotes. He also told victim Elayan that, quotes, he knew where she lived and was going to shoot up her home, end of quotes, period. Police advised you to stop calling the business. You said you were going to continue calling the business. That's just what's in the complaint. I'm not saying any of this is right or wrong. And did, in fact, continue to call the business. The defendant called roughly 125 times within 3 hours. So I just want to be clear. You are not to enter or go near that address of 19341 Allen Road in the township of Brownstown. Do you understand that?
Yes.
You're not to write, phone, see, text, email her or anybody else, or have anybody else do any of those things for you or on your behalf. Do you have any firearms?
Sir.
Do you have any dangerous weapons of any kind? All right, you're not to have any. Okay, do you understand that?
Yes, sir.
Now let me check one thing here. No matter the disposition today, you have a warrant out of Taylor. Are you aware of that?
No. No, sir. That was taken care of,
Well, you better talk to them because they think also you have another one out of Lincoln Park, also another one out of Jackson.
I took care of those. Actually.
This was run on June 12th. That was only, what's today, the 18th? That was only 6 days ago. So unless you went to all those places since June 12th, in the last 6 days, those warrants are still out for your arrest. I'm just telling you. You understand what I'm telling you? Yes?
Yes, sir.
Now, you also have to go over to Brownstown Police Department today to get fingerprinted and photographed. By 1 p.m., no matter what happens on this today, unless there's a dismissal, you're going over there by 1 p.m. today. Do we understand one another? And also, I'm going to just give you a lawyer. It's a serious allegation. So you have to go over to the Brownstown Police Department by 1 p.m. today. First, I'm going to give you a lawyer. You're going to talk to the lawyer. John, tell him I arraigned him. And then we will go from there, and the lawyer will go in and talk to the Brownstown Township Attorney. Do you understand that? Do you have any questions? I can't hear you. All right? You fully understand those bond conditions? Okay. Good enough. Schroeder. Justin Nicholas Schroeder, 244W835712. Could I have Alyssa Jones seated at the table over here? My right, your left. Your name, sir?
Justin Schroeder.
You're charged with failure to have your child attend school on all scheduled school days. That's count one. Count two, failed to provide proof of child attendance. Those are the charges. If you plead guilty or if you're found guilty, these would be two technical violations and you could be incarcerated for 10 days. Do you understand that, sir?
I do understand.
Did you sign the advice of rights and read and understand the rights?
Yes, sir.
If you plead guilty, you'll be giving up all those rights and there will not be a hearing or a trial. Do you understand that?
Yes, sir.
You have the right to a lawyer. If you cannot afford one, you can apply for one. I'll actually give you one. Do you want a lawyer?
Not at this moment.
Okay. Well, I'm going to ask you how you plead. Listen, slow down. So if you tell me, Judge, I don't want a lawyer, I'm going to ask you how you plead. If you tell me, Judge, I want a lawyer, I'm going to set you up with a lawyer right now. You understand that?
Yes, sir.
Okay. Would you like a lawyer to represent you?
No, thank you. I'd like to plead not guilty.
We're going to have a hearing then. You understand that?
Yes, sir.
All right. Calling Jessica. Have a seat at the table right behind you there. And I'm going to get the probation officer in here. Alyssa Christine Jones. Alyssa Christine Jones. 25B148251. Good morning, Ms. Aycock. Your appearance.
Good morning, Your Honor. Leslie Aycock, on behalf of Ms. Jones, who's present to my right. Can you please state your name for the court this morning? Alyssa Jones.
Defendant pled no contest to disorderly person public intox. This was to be under section 771.1. And she was referred for a screening and assessment. Have you had a chance to review the report, whether and are there any material additions, corrections, or deletions?
Your Honor, yes, I have received the report and I did review it with Ms. Jones. She indicates it's factually accurate. There are no errors or omissions to that report. Is that correct? Correct.
All right. Is there anything you would like to say on her behalf?
Yes, Your Honor. The recommendation was for 12 months probation. We would ask that that be reduced to 6 months. This is a non-serious misdemeanor. It would still allow sufficient time for the court to supervise Ms. Jones and for her to perform all the other requested terms of her probation. Other than the reduced sentence, we would ask that the court adopt the balance of the recommendation.
All right. So she and Mr. Machete have a child in common, correct?
That is correct, Your Honor.
Can she and the father of her child get along well enough where I can allow them to exchange visitation, effectuate visitation, or do I have to have this supervised at a police department?
I believe they can exchange the child, and there is a corresponding Wayne County Circuit Court case that maintains jurisdiction over the custody and parenting time case.
So they were never married, correct? But what was there there was a case filed in circuit court for what? Child support and adjudicating him as the father, or what?
Custody and parenting time. The parties had Ms. Jones and Mr. Machete had a living together relationship that produced one child. That child is the subject of I believe, a 2023 parenting time custody case. And I might be wrong with the year. I did represent Ms. Jones in that custody matter. But it was a couple years ago, and the court, of course, maintains jurisdiction. The child remains a minor.
Ma'am, anything that you would like to say?
No, Your Honor.
So I'm looking at your record here, and I hope that you're saying to yourself, I've been in trouble 3 times in my life. I'm 29, and all 3 have involved the use of alcohol. I mean, you had 2 other drunk drivings or impaired drivings, I should say, in 16 and 19. And this troubles me, and I hope it's bothering you because you cannot do this. Okay? We understand one another?
Understood.
Is Thomas Machete here by chance, Lisa? I should have asked that before, but nobody stepped up when I called the case.
Can you hear me now?
Now I can, yes.
Nope, not on Zoom.
12 months probation, you cannot leave the state. I will take it under section 771.1. You cannot leave the state without the consent of the court or violate any law or ordinance. If you change your address, your place of employment, or home telephone number, you must notify probation. You have to report as directed. No alcohol, no illegal drugs, no marijuana either. You're not to purchase, possess, or consume alcohol, illegal controlled substances, or marijuana. So I see you use marijuana. That was fine. It was legal, but now you cannot use it. Do you understand me?
Yes.
All right. No alcohol, no marijuana, no illegal drugs. Kratom, poppy seeds, and CBD oils are prohibited. Consuming food or other items containing those substances will be deemed a violation. They're recommending weekly testing. I'll make it bi-weekly for 3 months. If you're clean, I'll then make it monthly for 3 months.
Thank you, Your Honor.
If you're clean, then I'll make it on demand, okay? You're to attend the domestic violence weekend program. You're not to have any contact with Thomas Machete except to effectuate visitation. You cannot possess any firearms. You cannot possess any dangerous weapons. I mean, I didn't read in the report anywhere where she'd actually been to treatment before. In fact, it says she is not. Is that true? You never went to substance abuse treatment? You've had 2 drunk drivings. Nobody ordered you into...
Yeah.
Oh.
She indicates she has attended substance abuse counseling and treatment through prior court cases. The 2016 and 19.
The court here says has never been involved in substance abuse treatment. Ma'am, I want you to go into AA twice a week until you're in outpatient treatment. Ms. Aycock, you have a form that you can hand her, correct? An AA verification form?
I do not have one on me.
If not, call to extension 230 here and we'll send you over one, okay?
Thank you.
So you have to go twice a week, and every time you have to go in person, and every time you go, you have to have the form signed, and every time you come to court, you have to bring the form with you. You only have to do that until you're in treatment. Once you get into treatment, you no longer have to attend AA or NA. So that covers pretty much all of that. I'm telling you, though, I really am concerned about this. 4 days jail, credit 1, serve 3. I'm going to let you serve those as follows. 2 days on our court work program, $35 a day charge for that for 70. 1 day of community service, and I'll give you until August the 1st to complete your community service. $100 in fines, $200 costs, $75 victims' rights fee, $50 justice assessment. 4 1/4 are your fines and costs. Screening is $60 for $485. Probation fees are $240 for $625, and you have court work program fees of $70. Your total $695. If you violate, your probation could be revoked. You could be incarcerated for a period of 90 days. You have 21 days to appeal. You have 14 days to apply for a court-appointed lawyer for purposes of appeal. Again, no firearms, no dangerous weapons. You're not to possess any of those or purchase them. I'm going to give you a review hearing date, Lisa, and then you'll come back on that date. If you're compliant, this case will be dismissed on the motion of the prosecutor. Do you understand that?
Yes.
All right. Can she pay all of this today?
Your Honor, she indicates she can pay $100 today, correct? And that if she could pay the balance at the rate of $100 a month, starting 1 month from today?
Judge, can I get your total again?
Yeah, you're going to correct me. 695, is that right or wrong?
I have 795.
You're right. Thank you. See, you got to surround yourself with good people. 795. You are right. Thank you, Lisa. 795. You're asking kind of a lot. She gets $800 a week. I'm not saying she's rich, but you pay $100 today. I'd like you to bring it up and you set up your appointment. I'll then set you up on $65 bi-weekly, and I'll start that beginning on June the 27th. If you ever need more time, you come to the court or come on Zoom, call us, and I'll go on Zoom and I'll give you an extension. But every other week, $65. after you pay the $100 today, and probation will instruct you today. Any questions?
No.
Any questions? Anything else, Ms. Aycock?
Just the review date, Your Honor.
Oh, yeah, I still need that, right.
June 3rd of 26 at 9 o'clock.
June 3rd of 2026 at 9 a.m. June 3rd of 26. Wow. All right, have a good day. Good luck. Thank you.
Thank you, Your Honor.
Schroeder. Justin Nicholas Schroeder, 24W835-712. Your name, sir?
Justin Schroeder.
All right. Your name?
Vote on behalf of
He waived his right to a lawyer. He wants a hearing, and that's all true, correct?
Yes, sir.
You ready to proceed?
Yes, sir.
Raise your right hand. You solemnly swear or affirm under penalties of perjury that the testimony you will give in these proceedings will be the whole truth, so help you God.
I do, Your Honor.
Now, after she's done, you can ask her questions. And then I'm going to ask you if you wish to testify. You don't have to testify. I'm not going to hold it against you if you don't testify. If you do choose to testify, I'm going to swear you in. Do you understand that?
Yes, sir.
All right, you can proceed. 2 counts.
Your Honor, I have 2 counts. The first count is that the defendant failed to provide proof that the child attended school on all scheduled school days. I did receive proof from the school that there were 10 excused absences since the defendant was sentenced. The defendant was sentenced on January 8th of 2025, and there were 10 absences since then that were unexcused according to the school.
10 excused or unexcused?
Unexcused.
Okay.
And then my second count is that the defendant failed to provide proof of the child's attendance to therapy. I never received anything from the defendant regarding the child's attendance to therapy, Your Honor.
So, okay, Judge Kirsten just wrote down, he's sentenced January 8th, child to attend therapy, all scheduled school days and attend on time.
Correct, Your Honor.
All right.
May I offer an explanation, Your Honor?
Not yet. Do you have any questions of her?
No questions.
Do you wish to testify or do you wish to remain silent?
I will testify.
I'll ask you to raise your right hand. Do you solemnly swear or affirm under penalties of perjury that the testimony you'll give in these proceedings will be the whole truth, so help you God?
Yes, sir.
Okay, go ahead.
Okay. Well, first off, I have been doing the best of my ability to get him to school every day.
How old is he?
He's 9.
Okay.
A lot of these absences, like he was more than, 30 minutes late some days, and after 30 minutes, it's an absence. With the therapy.
How does the child get to school?
I drive him or take the bus.
Okay.
And now with the therapy, he has been on therapy since December 12th, I do believe.
All right, let me see the proof.
And I have it on my phone. I've tried to send it to the court. My last court date, I talked to the lawyer. There was 2 different lawyers actually, and they were supposed to turn it into the court. I don't know what happened with that. I have all the proof on my phone.
How many times has the child attended therapy?
School?
Therapy.
That
was December.
Yeah, almost every appointment is twice a month.
So I just want to be clear. Judge Kirsten sentenced you January 8th.
Mm-hmm.
That is 5.5 months roughly. Okay?
Correct.
So you're telling me that your child has gone, say, 11 times to therapy. Is that true or
That
false?
sounds about right, yes.
I don't want it to sound about right. Is that true or false?
I believe so, yes.
Okay.
I'll say that's true.
All right, let's see the proof of the therapy.
Okay, let me get it on my phone. Because I tried to email it to the court.
Why aren't you getting the child to school on time?
Well, I'm trying to. It's a bit of a struggle because.
How far is the child's school from your home? You live on Irene?
I live on Irene. His school is Yake, so it's not too far.
How far is not too far?
1.5 miles.
Okay, so that doesn't take you more than 7 or 8 minutes at most, even on a school day to get him there, right?
Correct.
Okay.
So, a lot of it is getting him motivated, inspired in the morning. Because sometimes he will just refuse or was refusing. Now, the past few months, I have made a lot of progress, and that is why I'm choosing to, not guilty, because.
No, it's not a question of making progress.
Judge, If I could add, there is a pending new parental responsibility charge that's in Judge Hessen's courtroom that was filed in April 24th of 2025. That has a pretrial that's scheduled today with Judge Hessen.
Is that right?
Yes. Yeah.
Wait a minute, slow down, man.
Here's the fair.
Slow down a second.
Yeah.
Slow down a second. Let me think this through a minute. Let's just deal with the therapy issue right now. There was no order that he attend therapy or no, well, let me just, yeah, let's just deal with the therapy issue right now. Show her the proof.
All right, this shows from the Guidance Center, it looks like their initial meeting date was December 11th of 2024. It does show that it is the child. On here, it's just the first page of this, so it just shows that there was an initial meeting. It doesn't show any list of visits or anything like that, Your Honor.
Yeah, they told me that was.
The judge didn't even order it until January 8 of 25.
He was in therapy before that.
I get it, but we need proof that the child's been attending since January 8 of 25. Nobody ordered the child to attend therapy prior to January 8 of 25.
Right. Well, then maybe it's a misunderstanding on my end on what the proof of attendance is, because when I asked his therapist.
You just got done telling me the child's been going twice per month,
Yes.
right? I need proof of that.
I will get proof of that from the Guidance Center then, because I thought
You've
that.
known about this case, this charge since February 7 of 25.
When I talked to the
Listen to
Guidance
what I'm
Center.
telling you, please. Judge Kirsten ordered this January 8th of 25. I signed this show cause back on February, the probation violation summons, back on February 7 of 25, and you were to appear here on February 20 of 25. You did not show. We issued a warrant for your arrest. On May 21 of 25, that warrant was canceled. It's probably, I don't want to make assumptions, probably in conjunction with the other charges. You were here on May 21, 25?
Yes, we'll assume.
Were you in front of Judge Hessen on that day?
Yes.
So I want you to think what I would be thinking right now, or what I am thinking, I should say, to put it a better way. You came to court with no proof. You tell me you have proof. You say you can't email it to the court. We sent you this show cause on February 7. It was scheduled for February 20, so you have effectively had somewhere in the neighborhood of about 4 months and 10 days to provide proof. Now you come here showing an intake appointment that occurred prior to the day in which the judge ordered it. That's all I had.
I was told that was the paper that I needed to show you. So I'm
Who told you that?
the Guidance Center, the therapist, when I asked her for the piece of paper.
All right. Do you have anything else you want to say? I don't want to talk about, look, I don't want to talk about, I did not know that you had another case pending in front of Judge Hessen. Okay? Until she just said it. So I don't want to talk about count one. I'm not going to even rule on count one. I don't have proof. It's your obligation to provide proof of child's attendance. That doesn't mean the intake appointment. You've had plenty of time to provide it. You absconded on this case. Just so you know, I could revoke your status and send you to jail for 90 days. Why you chose to ignore us, I don't know. Only you know. Listen, please. I'm going to find you guilty on count 2. Failure to provide proof of child's attendance at therapy. So just give me a moment, and then I'm going to tell you what I'm going to do. So I'm going to enter a guilty plea. I'm sorry, I'm going to find you guilty on count 2. I'm not going to rule on count 1. You have another case pending. Had I known that, I would not have conducted this hearing like this because you're still presumed innocent. Is that up for arraignment and pretrial, Lisa, today? Do you know?
I can check.
I believe it's a pre-trial for today, Your Honor.
All right, so I'm going to set a sentence date on count 2. Adjourn remainder of hearing as to count 1. I think you need a lawyer. Sounds this is getting worse as we talk.
I agree.
All right. We'll adjourn the remainder of the hearing as to count 1. I'm going to set a sentence date on count 2. I'm not going to render a decision on count 1 until the case is done with Judge Hessen, at least until there's a disposition as to guilt or innocence on that. All right. So I think, Lisa, we better adjourn this out about 4 to 6 weeks. And that'll be for sentencing as to count 2 and balance of the hearing is to count 1. So maybe I'm thinking the latter part of July.
Do you want it on a Woodhaven day?
I don't know that that's actually necessary, to be honest with you.
Okay. July 22nd at 8:30.
July 22nd at 8:30. Sir, we'll talk then. But you have to get in a better habit of following judge's orders. And are you a single father?
I am, yes. Full custody.
How many children do you have? Just one?
Yes.
I didn't say it was easy. I'm sure it's difficult for anybody, male, female, to have raised a child on their own. Only one person involved, it sounds like, but you have to get the child to school. And if Judge Kirsten ordered therapy, I'm sure he did so for a reason. And you have to get the child to therapy. So if you haven't been getting the child to therapy, I'd suggest that you call there today and that you get that child into therapy regularly before you come back for sentence. Do we understand that?
Yes, sir.
Okay.
The next time I see you, I can bring the actual proof that I thought I had.
Good.
Judge,
Yes.
I just noticed this is set for prosecutor review July 11th.
And this is under 771.
Or July 9th, I'm sorry.
I see. All right. July 9th, and I'm not here that day, am I? Is it in the morning?
It's in the morning.
That's a Wednesday, right?
Yes.
July 9th at 8:30. July 9th at 8:30, okay? You'll get your notice. You have to deal with the other case in front of Judge Hessen. Thank you. Good luck.
Thank you.
Timothy Sean Walsh, 25B14865-4A and B. Come on up to the podium, please. Salinas and Gillingham, I'm going to ask you to have a seat at the table and come up to the podium when I call your case. Your name, sir?
Timothy Walsh.
Mr. Walsh, you're charged with driving on a suspended and improper lane use, causing an accident. You have the right to a lawyer. If you want one, I'll give you one. You want a lawyer?
No, sir.
All right, so on May 29 to 25, it is alleged that you did operate a motor vehicle on Telegraph near Sylvan in Brownstown at 5:05 p.m., they think, with a suspended license. That's a charge that carries with it a possible penalty, a maximum up to 500 fines, 93 days jail. Costs are all those. 2 points would be added to your record. If you're convicted on the improper lane use, that's also 2 points, although you only get the higher of the 2-point totals. So you'd only get 2, not 4, if you were convicted of both. Do you understand that?
Yes, sir.
And did you sign, read, and understand the advice of rights?
Yes, I did.
If you plead guilty, you'll be giving up all those rights, and there will not be a hearing or a trial. Do you understand that? All right. You still wish to waive your right to a lawyer?
Yes.
I'm entering a not guilty plea. $500 personal bond. You cannot leave the state without the consent of the court or violate a law. You must appear in court as directed. Those are your bond conditions. We're taking you to the Brownstown Township prosecutor. She'll call you in as soon as she's able, and you'll pre-try the case with her. Any questions?
That's today.
Correct. Okay?
Thank you.
Any other questions?
No.
All right, good luck. Abigail Marie Salinas. 25B148617, A and B. Your name, ma'am?
Abigail Salinas.
You're charged with driving on a suspended and no insurance. No insurance, they're charging as a civil infraction here. You have the right to a lawyer. If you want one, I'll give you one.
Yes.
You want a lawyer?
Yes.
All right, we're gonna set her up with an attorney. You can go out in the hallway, he'll set you up with a lawyer. Just be patient, they've got a lot going, okay? Jordan Gregory Gillingham, 25B148459, A and B. Your name?
George Gillingham.
You're charged with failure to display a valid license, no obstinate person, no insurance. Those are both 0-point violations. You have the right to a lawyer. Do you want one? I'm sorry?
Yes.
Okay. We'll set you up with a lawyer. Go out in the hallway and you'll come back in front of me. Gonzalez. Sonia Idalia Gonzalez Corona, I believe. 25B148788A. Your name?
Sonia Lopez.
Okay.
Good morning, Your Honor. I'm Nelda.
You're what?
I'm Nelda Garcia. I'm trying to translate for her if you allow that.
You really have to get in a misdemeanor. And a civil infraction, I don't mind so much, but I'm not really supposed to have non-certified interpreters. So what I'm gonna do is, you're her friend?
I'm her cousin.
Okay. Well, thanks for coming. And I'm gonna adjourn this, okay?
Okay.
Lisa, we're gonna set another arraignment and pretrial whenever you want down there. Do you want me to, and we're gonna need a Spanish interpreter, right?
Correct.
Okay. So that's whatever day you wanna give me.
July 17th at 1:30.
July 17th at 1:30, okay?
Perfect.
And you go down the hall and we'll give you a paper notice, okay?
Okay.
Best of luck. Thanks. Felton. Kayla Lynn Felton, 25B8283, A, B, and C.
Judge, I had an attorney appear on that, but I don't see him in the breakout room anymore.
Your name?
Miss Felton,
You have a lawyer?
I got one this morning.
Who is it?
I have no clue. I'm supposed to be next door.
I don't know what that means.
I'm supposed to be seeing the other judge about this case.
I know you are. Where's your lawyer, though?
I have no clue. They told me when I go back over there that he'll call me in,
Wait a minute. Wait a minute. Did you hire a lawyer?
for the ticket, no. But for the case for next door, the court appointed attorney is supposed to be speaking with me.
Okay, wait a minute.
She's so per for this, Your Honor.
Your Honor, I can shed some light on what's going on.
Your appearance, why don't you come on in the courtroom if you would, please?
Certainly, Your Honor.
Your name?
Caitlin Foley Kerner from Preston Township.
Okay,
The attorney that was here was observing. He's from Preston Point Apartment Complex. They have a civil dangerous dog action pending, so he was here only to observe. So she's in pro per. She has one case here and two cases down the hall.
I read the brief. So you did not hire a lawyer though, right? You didn't pay a lawyer to represent you today.
No, I didn't know that I had to until I went to that court last week, I believe it was. Then she told me that for civil matters, you have to hire your own. But for the misdemeanor charges, I would get appointed one.
That's correct.
Judge, that's my fault. That attorney logged in as with Felton.
That's fine.
So I thought it was for her.
That's all right. Well, I'm troubled by this, what I read in your brief.
That's clear.
And you have the dogs in?
It's in township custody.
Right. All right, I'm gonna give you a lawyer. I'm gonna give you a lawyer on this. We're going to arraign you on this. You have three charges: no dog license, dog roaming at large, and then you have those are civil infractions. You have vicious act dog. We're gonna give you a lawyer, okay?
Okay.
And you will speak with that lawyer, and then you'll come back in front of me, and we will go from there. All right? Thank you.
Thank you.
Get Capel, or Capel, I'm sorry. Erin Elizabeth Capel.
It's
25I-415-021. It's Capel?
Hello, Your Honor.
What's your name?
Erin Capel.
Capel, okay. Did you meet with the department rep today?
No.
Miss Amami, can you hear me by chance? Good morning.
Yes, Judge, I'm here.
All right, so this is a department rep, and they wrote down that she wasn't here.
We actually asked and were told she never checked in, so I apologize for that. We'll talk to her if you want to put us in a breakout room with her.
No, she's right here, but this is an informal, so it has to be with the department rep. And I guess
And
he's,
he's here.
pardon?
Eno is here.
Yeah, so can you ask him to come in and get this file and get her expedited? She's been sitting here since I got on the bench.
Oh.
All right?
Yes, Judge.
Thank you.
Thank you.
I'm sorry. You go talk to the department rep and work this out if you can.
Okay.
Okay? Do I have somebody in here on Lori Potter? Ms. Patillo? Good morning. Lori Sue Potter, 25E-147-879A. And then I also have a Judge Hessen case for fair to pay $275 on 24B-146-892. Ms. Potter, your name, ma'am? You have to unmute if you would, please. Should be in the bottom left-hand corner of your screen. Ms. Patillo, your appearance? There you go. She's got the file.
Thank you, Your Honor. Thank you.
Ms. Patillo, can you hear me?
Hello?
Wait 1 second, ma'am. I'm going to get your lawyer in here, okay?
All right.
She already went out. She already went out.
All right, thank you, Your Honor.
Ms. Patillo?
See you, you're out.
Hello?
Ms. Patillo, I need you on Lori Potter if you're ready.
Okay, I'm ready. I'm about to join.
Come on in if you would.
Okay.
Thank you. Well, no, that's all right. You can join by video. That's fine. That's fine. All right, we're going to get your lawyer in here, okay? Just bear with me. Ms. Patillo, can you hear me? How's